I call the matter of Neil Lindsay Knight, nominee officio and member of the Executive Council for Health, Gauteng, for hearing.
May it please the Court. Justice Mhlahla, Justices of the Constitutional Court. I appear in this matter on behalf of the applicant, and I'm assisted today by my colleagues Jacobs, Steyn, and Mabuya.
Thank you, Mr. Maybeck.
May it please the Court, Justice Mhlahla, and members of the Court. I am A.B. Rousseau, and I appear with Linda Pretorius for the respondent.
Thank you, Mr. Rousseau. Please come. Don't run away, Mr. Mullins.
Sorry about that. So I appear for the first amicus together with Ms. East. Is it please?
Thank you, Mr. Mullins.
As it pleases the Court, I appear on behalf of the second applicant, or second amicus, together with my learned friend Pretorius, who will be making the submissions on behalf of the second amicus.
Thank you, Mr. Duplessis.
Thank you.
Mr. Maybeck.
Thank you, Justice Mhlahla. As a brief introduction, the applicant is seeking that this Court consider and amend a rule of the common law. This rule, we do not argue, was incorrectly applied. We argue the rule is incorrect. The rule does not align with the constitutional values and the Bill of Rights. This rule resulted in a severely disabled minor child being not only deprived of non-patrimonial damages in his claim following the negligence of the MEC. The SEA went so far as to state what the effect of this rule is. And the effect of this rule is a declaration of death. The child, due to no fault of his own, being disabled, was treated as if he was dead. In advancing my argument, I'm going to structure it. There will be 7 different sections that I will deal with. Firstly, I will identify the rule. Secondly, I will identify, according to the SEA, what the rationale is for this rule. Thirdly, I will submit and advance argument why we contend that this rule offends the spirit, purport, and objects of the Bill of Rights. Fourthly, I will advance argument as to how the rule should be developed. Fifthly, I will deal with the wider consequence of the development, thereafter with the jurisdiction of this Court, and lastly with the relief being sought. So, firstly, let's identify the existing rule. The existing rule, according to the majority of the SEA, does not recognize objective fact or catastrophic patrimonial deprivation as sufficient for compensation where a claimant lacks subjective awareness. So therefore, the rule can be summarized as follows. Absent subjective awareness of loss, there is no claim for pain and suffering. Furthermore, absent awareness of loss, the Court must determine whether this award can serve a purpose, a function. And insofar as the award cannot serve a function, the claimant, in this instance the minor child, was not entitled to such an award. And based on those 2 criteria, the SEA dismissed or upheld the appeal by the MEC and dismissed the claim for general damages. Now, on a basic reading, it seems that the rule as pronounced by the SEA has 2 legs to it, where we as the applicant argue a more general argument, and that is that this rule in its current form deprives this minor child of general damages in toto. And I think at this point I need to elaborate why that is our statement. Firstly, insofar as it relates to the pain and suffering, I think it is self-evident. But secondly, we must consider the purposefulness or the functionality approach adopted by the Supreme Court of Appeal. Because that functionality approach moves away from what has the child lost and moves into the realm of what can we buy, which can be of assistance, which can help. What can money buy? And the minute we move the focus from what has been lost to what can we buy, we move from non-patrimonial damages into the realm of patrimonial damages. And that is exactly evidenced by the judgment of the Supreme Court of Appeal, the majority judgment, where they found that because of the provision of future medical care, which is a patrimonial damage, he's not entitled to non-patrimonial damage. So at best, the approach adopted by the Supreme Court of Appeal equates to non-patrimonial general damages being changed in its nature to patrimonial damages, which results in no non-patrimonial damages. And that is why we use the sweeping statement that even with the qualification applied by the Supreme Court of Appeal, this child, and any child or any individual in this position, is deprived of general damages in toto. The second section of the argument is what is the underlying rationale for this? And again, I refer to the majority judgment of the Supreme Court of Appeal. Now, we can categorize the reasons as being that first, there's a compensatory principle. Secondly, it must be purposeful. It must serve a purpose. Thirdly, general damages protects a highly personal interest. And the award is therefore not made for the benefit of anybody save for the victim. And then the relationship between general damages and special damages, which I just touched on slightly, is also used as a rationale because there are patrimonial damages which adequately make provision for certain interventions. So the reasoning is reduced to its essential proposition is the following. Firstly, damages are compensatory, not punitive, and an award must therefore perform a compensatory purpose. Secondly, because money cannot restore non-patrimonial interest, such as loss of amenities, the function of the award is to provide some form of solatium, consolation, or other benefit to the injured person. And thirdly, because the interests protected are personal to the claimant, that benefit must accrue personally and exclusively to the claimant. And I can add to that. The other rationale is because it's always been like this. Historically, from Roman Dutch times, the law handed down to us has made provision for it that subjective awareness is a sine qua non. The third section of my argument. Can a common law rule founded upon these propositions be reconciled with the spirit, purport, and objects of the Bill of Rights? Now, before we examine this more closely, I think it's apt that we consider what is general damages. And for me, luckily, this court has pronounced in Van der Merwe and has dealt in detail with this. And I can do no better than the then Deputy Chief Justice Moseneke in paragraphs 38 to 41 of the Van der Merwe judgment. But in essence, in paragraph 38, we have special damages, which is aimed to redress, to the extent that money can, the actual or probable reduction of a person's patrimony as a result of the delict or breach of contract. Also described as a true equivalent of the loss. And that includes future medical care, loss of earnings, and ancillary expenses to be incurred as a result of the negligence, to ensure that the claimant is placed in the best possible position as if the incident did not happen, as if the, in this instance, neurological injury did not occur. So it's, to a large extent, an exact determination of an actual loss, quantifiable in money. In paragraph 39, Justice Moseneke then explains that, on the other hand, non-patrimonial damages, which also bear the name general damages, are utilized to redress the deterioration of a highly personal legal interests that attach to the body and the personality of the claimant. So here, evidenced from these two paragraphs, we have non-patrimonial or special damages, the question, what can we buy? Non-patrimonial, general damages, the question is, what have you lost? And then in paragraph 40, Justice Moseneke expands on the general damages and the scope thereof by stating that besides bodily integrity, our law recognizes and protects other personality interests, such as dignity, mental integrity, bodily freedom, reputation, privacy, feeling, identity. And then importantly, the concluding statement in paragraph 40, a wrongful reduction of the quality of these personality interests or rights entitles a victim to non-patrimonial damages. And then the concluding remark at paragraph 41. After all, the primary object of general damages, too, in the non-patrimonial sense, is to make good the loss, to amend the injury. Its aim, too, is to place the plaintiff in the same position that he or she would have had but for the wrongdoing. So again, I emphasize, it is two different questions. In patrimonial damages, it is a question of what can we buy. In non-patrimonial damages or general damages, it is a question of what have you lost. So let's start examining this test against the constitutional principles. And the first principle I wish to refer to is the principle of dignity. Now, I must profess, in preparing this portion of my oral heads, or of my oral submissions, I struggled. I struggled to come up with some formula to advance today, which I think adequately explains what dignity is. To explain why human life is sacred and precious. And in doing so, I continuously reverted back for, let's call it inspiration, to the judgment of Makwanyane. And it became evident to me that I do not believe that my struggle to actually put to words what dignity is not only mine. And I saw in Makwanyane a judgment of 200 pages, of judges agreeing, but all of them wishing to add something. All of them feeling that they can add to this debate as to the importance of dignity. But what is evident from that judgment is that human life and dignity is precious, and we afford it dignity, not because you deserve it, not because you've earned it, not because you think you deserve it, but because it's intrinsic in human life. we regard it as precious and dignified. And we cannot ignore the history of this country that led to the writing of Makwanyane. But I feel that Makwanyane evidences the importance of dignity. And we must also consider that who was Makwanyane? And I say this with all due respect. If there wasn't an individual that was deserved of less dignity, maybe it was him. Now let's juxtapose the treatment that Makwanyane received to the treatment that the late Master Shongwe received. It's striking. It's striking to see that an individual, a murderer that has received the death penalty, is held in this dignified esteem, whilst a young boy who suffered tremendous neurological injuries as a result of negligence is regarded as dead. But in reading Makwanyane, there was another similarity between the present matter that this court has to consider and Makwanyane, which came to me. We accept Makwanyane dealt with the death penalty and the undignified nature of that, and the infringement on the dignity of those people so sentenced. But if we consider Master Shongwe and the test that the SCA used, we find that the SCA...
Mr. Maybeck,
Yes.
I'm sorry to disturb you. We are strict with anonymize the names of the minor children.
My apologies.
If you wish, either say Craig or minor child.
My apologies.
Thanks.
The test being applied by the majority of the SCA is the test for a vegetative state, as pronounced by Justice Therion in the matter of Clark versus Hurst. But what is the context of Clark versus Hurst? The context was not that Justice Therion was asked to consider whether somebody qualified for general damages. He was asked to terminate life. He was asked to authorize the seizing of medical intervention on a patient, which they argued was in a vegetative state, which would have resulted in death. So that is another striking similarity between Makwanyane and the present matter. The present matter, the test, was never a test designed for the determination of general damages. It was a test that was designed and is internationally applied in considering whether life should continue. And I think that the use of that test and the use of Justice Therion's pronouncements on that in the present matter resulted in exactly that. It resulted in a finding that this minor child is as good as dead. It emphasizes the inappropriateness of utilizing vegetative state, which has no place in general damages, and forcing it into this discussion where it does not belong. It is my submission that at best, in the present matter, you can say that this child had a total inability to communicate awareness. So, secondly, further with regards to dignity, there's a striking finding made by the majority of the SCA when it relates, and they referred to an argument that I made regarding dignity. And they said that because of the provision for future medical intervention, because of the special damages, his dignity has been restored. Now, let's just for the moment interpose and ask ourselves, what is the substance of that finding? And as an example, somebody is rendered incontinent as a result of the negligence. I think we can all agree that that is undignified. It constitutes a continuous infringement of dignity. But now what the SEA finds, in effect, is to say, but I'm giving you a nappy. And by giving you a nappy, I'm restoring your dignity. It shows a total misapprehension of what exactly dignity is. Dignity is being able to walk, being able to enjoy life. Using Justice Fabricius' statements in Stratham Ford, being able to experience love. Being able to be a normal child, feed yourself, not using a peg tube. None of that has been restored. But the mere fact that we now provide money so that you can buy food, which we insert through a peg tube in your stomach, how is that a restoration of dignity? And I think that is probably the most pertinent evidence of a misapprehension of what exactly dignity is. On my reading of the judgment, and I'm subject to correction, I found reference to dignity once in the Supreme Court of Appeal judgment. Just for comparison, and again subject to correction, Makwadiane refers to the word dignity 143 times. The test that is being used, the common law test, enforces a principle that you, as a child with a brain injury, are deserved of less dignity than anybody else. That offends the Constitution. Let's consider the question of arbitrariness. Moving on from dignity, let's consider arbitrariness. Justice Ackerman in the Makwanyane judgment pronounced on arbitrariness, and he stated that a constitutional state demands rules whose operation is capable of rational explanation and justification. Arbitrariness inevitably produces unequal treatment of persons who are similarly situated. In the present matter, let's consider for the moment the minority judgment, because I think there is no better evidence of the arbitrary nature of this test than to consider the minority judgment versus the majority. Where the minority judgment, the exact same record, the exact same legal principles, differed on awareness. So this test asks of just judges and asks of lawyers to make determinations about awareness. And in the present matter, we had a minor child that would cry when he's in pain, that would cry when he's hungry, and that would cease to do so if he was fed or given medicine. The minority judgment finds that to be awareness. The majority judgment finds that not to be awareness. Because judges are now saddled with the impossible to make these determinations based on medical evidence. As judges are not capable or fit to do so, and it would by necessity result in unpredictability. Further evidence of the arbitrary nature and the unpredictability of this is a matter that I refer to in our heads of argument, the De Pre matter, which is a Makanduga, Eastern Cape matter. Now, I interpose to state that, probably to my own detriment, I was the counsel in that matter. And notwithstanding my intricate knowledge of this matter, the present matter, and the differences, I could not persuade a judge to find that child in that matter in a vegetative state. And that was a child that was watching TV and laughing at Mr. Bean, appropriately, that communicated hunger. So that is the result of this. It is arbitrary. It is discriminatory as a third ground, and it's discriminatory on a listed ground, being disability. Now, I accept that the comparator in this matter is also a disabled child. But the point is, the distinction is on the severeness of mental disability. See, once you've passed a certain threshold, you are treated differently than a disabled child that has not passed that threshold. That is discriminatory. It's on a listed ground. It's unlawful. On equality, I propose that the Harkson test, if applied to this matter, results in a finding that the principle, the test, does not comply with the Constitution. Does the rule differentiate? Yes, it does. Is the differentiation rationally connected to a legitimate purpose? Well, I've submitted the reasons why the SEA say the rule is of force, but I must submit I do not regard that within the constitutional context as convincing reasons. Does it amount to discrimination? My submission is yes, it does. There's a differentiation between awareness, which is part of a disability, and the rule selects a disabling characteristic caused by the neurological injury and uses that characteristic as the criterion for less favorable legal treatment. So because he was hurt more, he gets less. He is treated differently. Is the discrimination unfair? It is. We are talking about the most vulnerable of people in this country who did nothing to deserve this, who was rendered such by negligence. They are deserved of the utmost protection and not the differentiating treatment. That also relates to the impact of the discrimination. So because your neurological disability is so profound that you cannot appreciate what you have lost nothing. Objectively, and there are evidence of photographs in the record, that child lost a lot. His existence up to the time of his death was an existence showing a continuous infringement of his dignity. So on application of the Harkson test, I submit that the common law rule should be found to conflict with the Bill of Rights. And lastly, we cannot ignore Section 28 as a paramount provision, best interest of child. I do not think that this evidences the test applied and the treatment evidences best interest. So how should the common law be developed? Subjective awareness and the ability to demonstrate some functional use for monetary award is not a prerequisite, simply a factor to be considered in the exercise of a discretion. It cannot be used as the lock to open the door. It can be considered in adjudicating and in exercising the discretion to find what is fair and reasonable, because it will impact on pain and suffering, that I accept. But you cannot use it in this manner to exclude a child from consideration of general damages in toto. The consequences of the proposed development I propose is positive. It fits into the existing infrastructure, legal structure. It enforces the right to claim a well-recognized claim in non-patrimonial damages. Awareness does not disappear. It is simply considered. It will not open the floodgates. And most importantly, I believe it will create certainty rather than create uncertainty. Due to the arbitrariness of the test itself, I believe it will advance certainty. Turning to the sixth portion of my argument, that is the jurisdiction of this Honourable Court and leave to appeal. I believe that we have, considering Section 39(2) of the Constitution, we have invoked the jurisdiction of this court. I've believed we've directly introduced a constitutional issue, and which has huge bearing, far transcending these litigants. So I would therefore propose that the court has jurisdiction and the applicant should be granted leave to appeal. And then finally, the relief being sought, we propose the order that the appeal against the judgment, the majority judgment of the SCA be upheld, and that it be substituted with an order that the appeal be dismissed with costs, to include the costs of two counsel, and we also see costs in these proceedings for two counsel. That is my submissions.
Thank you, Mr. Maybeck. I'll start with the submission that the rule does not discriminates against the child. The respondent says that the rule in fact treats all injured persons equally, but what is important is the status or the state of the person, whether the person is aware or conscious or not. What is your response to that argument?
Justice Mkhlanhla, to determine the discrimination aligning with Harkson's approach, we must ask whether there's a differentiation. Now, the differentiation is between awareness, and I need to qualify, it's not between awareness and a lack of awareness. It's between awareness and a lack of an ability to communicate or show awareness. That is a differentiation. I accept that this is all within the realm of disability. So certain disabled people will be treated differently in that they qualify to be awarded general damages. Certain disabled people will not qualify to receive general damages. That is a distinction, it's a differentiation. And the differentiation is based solely on the severity of the injury. So you are using disability. Yes, some disabled people are treated different than others, but it's the level of disability which is being utilized. And that is on a listed ground. And there's no rationale for it. There's none, except what the SCA held on to, being the archaic principle as handed down to us. There's no justification to say to a judge that you may not consider general damages. You may not consider what you regard as fair and just, because this individual, this child, does not know it. I believe it is evidence of differentiation on a listed ground without any proper rationale to it. There's none, which equates to discrimination in conflict with the principles of the Bill of Rights.
The rule that was set out by the majority of the SCA, the first thing that the judge did was to consider whether the child was conscious or
Yes.
not conscious.
Yes.
there are reports that were filed by the experts. Out of, I think about, I'm not sure whether it's 7 or 5, but the majority said the child, there was some consciousness. He felt pain. In certain respects, he was aching, he would cry. And then there are 2 that said he did not feel any pain. And both said they got the report from the mother. What do you make of that, number 1? And number 2, the fact that the majority then said, despite the fact that there were 5 or so reports that said the child felt pain, but the court made a different conclusion on that aspect.
Justice Mhlantla, I need to tread carefully now. And I accept that there is criticism to be leveled at the argument, but I do not want to stand here today and argue in this court that the SEA erred in that regard. I am careful and attentive to what vests the jurisdiction of this court. But what we do find, and I can attach that to the arbitrariness at the very least, is we find judges analyzing crying and deciding whether that crying is evidence of an experiential, of experiencing pain, whether that crying is evidence of some subconscious awareness. And I think it's an unbelievably difficult position to place a judge in. But yes, there were reports that the child would cry when in pain or in hunger, and that he would cease to do so. Now, my submission is that is evidence. That is, in the basic essence, it's communication. The child communicates a state. The state is addressed by medicine or food, and it ceases. It's a form of communication, albeit so primitive. So I do not want to argue that the Supreme Court of Appeal patently erred on that factual finding, but I can use it as a basis to argue the arbitrariness. Because similarly, and the same record that is serving before this court this morning served before the Supreme Court of Appeal. And the court will find that there is no information regarding the award for future medical care, how that was structured, how it was computed, what was incorporated, what the contingencies were, what was excluded for duplication, whether it was for basic necessity or whether there were some other provisions being made. None of that was before them, yet they found it to be a restoration of dignity. And I also think that is an unjustified leap. But again, I'm going to utilize that in substantiation of my argument of arbitrariness. Judges should not be asked to judicially consider, within this context, whether there's awareness, using a test that was actually designed or formulated to determine whether somebody should die. Judges should judge and exercise a discretion on everything. Pain and suffering and what would constitute fair compensation will be impacted by a lack of awareness. I accept that. But you cannot use it as a sine qua non, as was done in the present matter.
To do is to look at what the SCA did insofar as this rule is concerned and make a determination whether a subjective test or an objective test should be applied.
The SCA, as I said, and they word it differently to what my proposition is, what the rule is. But they worded it as a sine qua non for pain and suffering. And then they worded it as, then there must be a purposeful approach. We must consider what can you do with this money. Now, that purpose can be one of 2 things. It can be a functional purpose, which is I buy you things. Or it can be a solatium purpose. I'm going to give you money so you feel better. But that's a circular argument. So the purposefulness can never be the solatium because the finding is there's no awareness. So the only purposefulness that can be attached is a functional purposefulness to the exclusive benefit of that individual. and that is special damages. By its nature, it is not non-patrimonial. So therefore, there is no general damages at all, even if they find purpose. It's still not general damages. It still does not satisfy the aim of general damages. And let's, in my submission, look at him. Objectively, anybody that looks at him must see the tremendous loss. At least compensating that, I submit, relevant or not, gives solace to us, gives solace to a community, gives solace to people that cared for him. So there is solace in this. Because my submission, anybody that sees what happened to him and reads the statement that he is regarded as dead must be affronted.
Mr. Maybeck,
Yes.
my understanding and my approach, if one were to cut out all the legal niceties about your subjective, objective, functional approach, would be, you must correct me if I'm wrong, adopt a common sense approach. And when you adopt that common sense approach, you ask yourself, okay, let's transport it backwards to the day when the child was born, right? When the mother was told, here's your baby, look at the baby and look at the child, and with all its deficits. What is it that the mother saw when she looked at the child? She saw a living human being. And one would imagine that the mother at that time was able to cuddle, appreciate the gift that she had, if she believes in God, and the big gift that she has from God. And then she was happy with what she had. Right? She takes the child home. On a common sense approach, you cannot say what she took home was something or somebody that was non-existent. I don't want to use the word dead. It was something or somebody that the mother was able to appreciate. And because of the problems that the child had, the mother developed a language that she utilized to speak to the child. And the child responded. There must have been communication between the mother and the child. And if there was that communication between the mother and the child, then how then can we say that because there was no intellectual awareness of pain, therefore that child from day one in hospital to the day when she departed from this earth did not lose any amenities of life. You and I and anybody else's in that compromised condition yearns or lacks those amenities. And then if we are to say, this child was born on that particular day and was unaware, and what was taken home, or to put it more crudely, hospitals should have said to the mother, you can't take the child home. The child is as good as not existing. That is something that I don't think the law would countenance. Now, that brings into equation your equality right of Section 9. Why is this child, compare this child with somebody who is less disabled, say it's a paraplegic. Why should there be that unequal treatment between the two? And if there is that unfair discrimination, it harks back to the Huxon Lane case. Now, the other thing that worried me as I read it was, by virtue of what fact or facts can a court come to a finding that this child lacked the intellectual awareness? Were tests done on the particular child, like you prick to see whether the child is sensitive to a particular stimuli or not, to say, you prick it, you prick the poor child, there is no response. And if there is no response, and that means there is no awareness. But we know from the experts that my sister presiding has alluded to, there were 4 or 5 experts that objectively describes how this child responded. It may not be what the majority of the SEA paid close or particular attention to, but objectively, there was a response, there was a communication between the mother and the child. What do we do?
Justice Matopa, firstly, I've already criticized the use of the test as pronounced by Justice de Leon. But if we consider that test, what that test says, it refers to in a learned manner. Now, I do not read that test as being indicative of an intellectual manner. I read that test as being indicative of something that was learned. To use an example, in the Dupree matter, for instance, we had a child who, if he soiled himself, would pull his head in a certain manner, indicating to his grandparents that his nappy needs changing. Now that, in my submission here, is interaction in a learned manner. It is something that was learned as a way in which to communicate something. It's not intellectual. But again, we must consider, if you take a child born and he can't hear and he can't see, how do you interact? How do you learn anything? You are physically prohibited from learning speech. How are you going to learn it? You can't see. You can't walk. You can't interact with the world around you. How are you expected to learn the ability to communicate, apart from the primitive? Apart from those reactions that you would normally find in a reptilian brain, and a reaction to pain, being crying. That was a form of communication in the present matter. So, and that is why, due to the nature of the disability, my submission to this court is, at best, you can find that there is an inability to communicate awareness in a learned manner. That is at best, generally speaking. Did this young child interact with his mother? No doubt. She would care for him. She would wake up 3-hourly sometimes. She would treat him because she knew he was uncomfortable. She would make him comfortable. He would go back to sleep. She would go back to sleep. That is an interaction. But the Supreme Court of Appeal went and said, but that what you see there, the evidence there is not indicative of pain, it's not indicative of awareness. But again, I need to emphasize, I do not want to argue myself into a position where I oust the jurisdiction of this court. But there is errors. There's factual errors, interpretive errors that were made. But I'm utilizing that errors and advancing the arbitrary argument as a constitutional objection to the test as it is currently formulated.
For us to, or for one to arrive at a finding in support of the majority, correct me if I'm right, would one then arrive at a finding that says, on the objective evidence, as explained by the experts, the child was in an unresponsive state to a point where she was unaware. Let me put it very clear. I just have a problem with this intellectual awareness. I just don't know where it comes from. And
Justice
unless if you've researched it and check where it comes from.
Justice Matopa, there's no expert in the world that will say that there's no awareness. We do not know. We hold human life as sacred. Religions attach a soul to that. Wherever you go, there's a higher value being placed on it. And that question is why? There's something more to that life than the mere sum total of what you see. We all experience it. We all feel it. And we all look at the photographs and we think, this is so sad. But now, with this archaic test, coming from a time where there weren't even disability rights, with this test we now must say, listen, let's find him as good as dead. And there's something to be added to this. Let's, for the moment, say that the MEC of Health filed a counterclaim to say, well, he's vegetative. Therefore, we do not intend to pay for anything. There's no reason to sustain this life because it's no life at all. So court, rather than order me to pay special general damages, why not just seize the treatment? Because that is the result of a positive finding of a vegetative state. Now the court can consider seizing the treatment.
Just stop there. What would encourage the courts to be inclined to order special damages if at the stage when a patient or a minor child is discharged from hospital, the diagnoses are that or the same as the child in the present case? Would a guilty hospital or let's not hospital, let's just a guilty wrongdoer with the means, obviously, be encouraged to say, let me try and ameliorate the condition of this child. But wouldn't they adopt a posture that says, whatever we want to do will not compensate the child, whether specially or generally? It's as good as throwing good money after bad. Yes, we are wrong, but so be it, and shrug their shoulders away from it.
I sincerely believe that that is the approach that can be adopted once you enforce this vegetative state into this equation. Once you find that the more you hurt, the less you pay. It's a hugely dangerous slippery slope.
All right, thank you.
And just finally, I omitted it in my main argument, regarding the awareness, we should also consider the life expectancy in the particular matter was 15, which means that from birth, a deterioration occurs. That deterioration leads to death. In the present matter, slightly earlier than was expected. But the mere fact that you actually test a child on a specific date is simply but a snapshot in time. It's a reflection of the neurological condition of the child at that point. It is not a reflection of the neurological condition of that child 6 months ago or 6 years ago. Again, related to the arbitrariness. So depending on when you did do the test, they do deteriorate. And this leads to death. So depending on when the test is done, you simply get a snapshot, but you do not get a correct picture of the neurological condition of the child for the entire period of existence now.
Maybe just one last one.
Yes.
Before I step aside, I hope, time permitting, we would have an opportunity to discuss and debate all the compendium of the judgments that the SCA collected in support of its decision. I don't want to hog the space, but we will do it at some point if time permits. Okay.
As it pleases.
Thank you, Mr. Myburg. This is not an easy matter because what it requires of us is almost to discharge our judicial function within a context that raises deep philosophical questions about life, its very meaning. But it's unavoidable in a sense because the law of general damages to some extent has been shaped by philosophical approaches and different approaches over time if you track through the history of damages. One of the issues that just emerged as you were debating with Justice Matopo around awareness and how you assess awareness, whether there is awareness or not, and whether if there is awareness there's an inability to communicate it, is in a sense the real risk that we judge this matter on the basis of the assumptions we make as able-bodied persons. And those assumptions then shape and inform how we see questions of awareness, questions of communication, because we judge it by reference to our own understanding of what is normal. So I thought I'd just locate it within that context, and I have a few questions then. The first part of the rule that you find offensive is the one that says, absent subjective awareness of loss, there is no claim for pain and suffering. Now, the SCA in dealing with, it didn't deal with special damages because that wasn't the subject of appeal, but in dealing with the relationship between special and general damages, which it said was important, and I accept that, remarked at paragraph 58 that the award of special damages was geared at ameliorating the child's suffering. So it seems to me that it recognized that there was suffering. And I'm not wanting to elevate it to awareness. And for the purpose of special damages, awareness wasn't a consideration, but simply the fact of suffering. And if I may say, would have seen Craig as a living person for those purposes. However, when it moved on to deal with general damages, it accepted that Craig was suffering, but it said that was irrelevant. And it seems to me that there's a difficulty in a judgment that for one purpose accepts the very fact of suffering, but for another purpose seems to consign it to an irrelevant consideration simply because there was no awareness of the suffering. One could possibly argue that if there was no awareness, then is an award of special damages justified because Craig is not aware that he's suffering. And so if you recognize that there's suffering and you want to ameliorate it just through special damages, it would seem to me, a fortiori, you would have to be able to deal with suffering as a reality in general damages. So I just want your comment on that, firstly.
Firstly, I do not believe that the function of special damages in the present matter or in any matter is necessarily or directly to reduce or ameliorate suffering. The idea behind the special patrimonial damages is to try and restore this young boy into a position that he would have been in but for the negligence. Now, I accept that it's an impossible exercise. It's an absolute impossible exercise. But the aim of the special damages is not to ameliorate suffering, is to provide treatment, to provide for his care, for his needs, for mobility, for wheelchairs and the like. Why is it provided a wheelchair? Because otherwise he would have walked. He would have walked to provide a wheelchair. So it might, by implication, result in an amelioration of suffering that I accept. But it was never the function of special damages to address the suffering. Justice Colopin touched on an issue, and I need to confirm that. From his birth, he had a life expectancy of 15. That the determination of special damages was done, actually quantified based on this life expectancy, and with the emphasis on life. He was a living human being who would receive certain treatments and certain medical intervention and other assistive devices to assist in his life. Yet when we revert to the non-patrimonial side, there's a finding which equates him to a non-life.
Okay.
And again, the one question is, what can I buy you? Special damages. What can I, or what have you lost? That's general damages. And the approach by the Supreme Court of Appeal, again, evidences what I'm arguing. They are moving from the non-patrimonial into the patrimonial, thereby depriving any victim, or in specific instance this young child, of the non-patrimonial.
Okay. My second question really goes to the heart of the matter, and that relates to the second part of the common law test that you find offensive, which is the question of awareness. And I want to understand you specifically. Are you saying that awareness is not relevant in establishing whether there was a loss, but it may be relevant in quantifying that loss? That's how I understood the last part of your argument. Is that correct?
We are currently using, albeit that the wording is slightly different, we are currently using the subjective awareness as a sine qua non. If you cannot show subjective awareness of the loss, then we cannot open this door to non-patrimonial damages.
I understand that
And my
submission.
argument is judges should judge. The subjective awareness or lack thereof would in any circumstances remain a relevant consideration to be exercised judicially by the judge in determining what is fair and reasonable.
Yes, I understand that, Mr.
Yes.
Maibuga. I just want to get to the heart of it. So you're saying that it can't be a barrier
Yes.
to a court coming to a conclusion that there's an entitlement to damages.
That is correct.
However, it is a factor to be considered in computing those damages.
That is correct.
Now, I want to unpack that. Firstly, are you saying in this case, how should that apply, if it should apply at all?
In this case,
If I understand you correctly, so that we can use our time efficiently,
in this
it
case,
should not prevent the principal question being answered in favor of your client, that there's an entitlement to an award. Is it relevant in the second question?
in this case, it should be applied as was done in the court of first instance. You consider all the facts. You look at his level of consciousness or awareness. You look at the pain and suffering evidenced by him objectively. You look at what has been lost, and you determine a fair and reasonable amount for general damages, which is exactly what the court of first instance did. Look at everything, consider everything, and arrive at an amount which is regarded as fair, just, and equitable in the circumstances.
So just on your submission that awareness is a relevant consideration in the second part of the test, I just want to test that. The argument in support of it being a consideration is that a person who is aware can experience the anguish of knowing that they lost something. So a concert pianist who's no longer able to play the piano will think about the days when she was able to play the piano, and therefore that's seen as a basis, the solatium. Whether it does that is another matter. But those who argue against that say that your inability to experience happiness and your inability to know the loss was caused by the wrongdoing. And so why should that become a factor that should moderate, as it were, your loss?
Justice,
So my question really is whether, if it is to be taken into account, what is the justification for taking it into account?
if I might use an example, so that I think I convey my submission properly. If I sustain a scar over my face, I'm 53 years old, I look what I look like, my subjective awareness of what I've lost will be vastly different to the subjective awareness of a beautiful young woman, 23 years old, that sustains the same scar over her face. Now, that is not pain and suffering, it's a subjective awareness of what I have lost. So in that sense, it is relevant. And in proper judicial consideration, I will most probably receive less general damages than her. So in that sense, it is the subjective awareness of a loss, and that is, generally speaking, is always relevant. We can argue that in the present matter, if we actually look at the specific group of claimants, these group of cerebral palsy children or severely mentally disabled children, the subjective awareness will play a far lesser role, if any. But as we are considering a rule which should be capable of general application, it is my submission that subjective awareness is but one of the factors to be considered. In the present matter, it should actually to a large extent be irrelevant, but in other matters it might be more relevant.
Just on that score then, if it is to be considered, would you accept that then it would constitute a differentiation between those who are capable of subjective awareness and those who've lost the capacity for subjective awareness? And if there is such a differentiation that may constitute discrimination on the basis of disability, what would be the basis to justify that?
I would not accept that that would constitute a differentiation or discrimination. I would simply submit that that is one of the factors that the court considers. Everybody is treated equally in the consideration of factors. It becomes differentiating if you start to exclude.
If you pay down an award by 70% because you're disabled to the extent that you lack awareness, that's a differentiation.
I accept that.
And it's a differentiation that has a negative effect because you reduce a benefit that you receive.
I accept that, Justice.
And therefore, if it's based on disability, then certainly Papuda says that it's presumed to be unfair.
Yes.
So on what basis would one be able to argue that that is a fair basis to discriminate?
Justice Golopin, I can take it as far as to argue that my submission is that the subjective awareness element forms part of the bigger consideration to be considered in determining general damages. I accept that you cannot use that to differentiate, which might result in discriminate. That you can't do. But we must give courts as wide a discretion as possible to arrive at the fair and just figure.
But courts also have to function within the spirit of the Constitution.
That is correct.
Lastly, Mr. Myburgh, you've spoken about the difference between, let me just get that right, what has been lost and what money can buy.
Yes.
Now, in Van der Merwe, in dealing with non-patrimonial damages, this court said that general damages are illiquid and are not instantly sounding in money. They are not susceptible to exact or immediate calculation in monetary terms. And then importantly, it said, in other words, there is no real relationship between the money and the loss.
Yes.
And is that not at the heart of this matter? Because the fight is about the money. But if this court has said there's no real relationship between the money and the loss, it would suggest to me that the idea that the money can compensate for the loss is a fiction, in part. Because, again, the concert pianist who's given R1 million in general damages but has been compensated for loss of earnings, etc., and who's worth a lot of money, that money may mean nothing. A mother who's lost her ability to look after her children, who receives a massive award and gets some money for general damages. So the question that I really have, and maybe Mr. Rousseau will have to respond to that as well, is that if we accept that there's no relationship between the money and the loss, then what's the relevance of awareness at the end of the day? Because awareness would suggest that there must be some relationship. This awareness of the loss is moderated by the money. But if the money doesn't do anything, and I think Van der Merwe accepts that ultimately, for practical purposes, we have no other way of making good this loss than through an award of money, because that's all we have to give. Our love might not be sufficient.
Justice Colopin, I believe that the whole theoretical principle of general damages and the solace element, the happiness element, I think is to a large extent a judicial fiction that we have created. In a lot of instances, especially in very severe matters, the general damages, non-patrimonial damages, does not make somebody happy. It does not. I recently dealt with a 19-year-old student that became a quadriplegic and has a life expectancy of 40 now. Money's not going to make him happy, but it is what have you lost, and that is what is being compensated. And I fully agree, there is no actual relationship between the money and the loss, but it is the only way in which courts can formulate a compensation. It is the value that we attach to a loss which is actually, we can't fix it.
Thank you. Thank you, Mr. Moe.
Thank you.
Mr. Mullins, I just need to understand the amendment or the development, sorry, that you're advocating for. At the heart of it is that the element of personal attachment, personal attachment of the compensation should fall away. Am I right? Or
The development we are proposing is that following the formulation by the Supreme Court of Appeal of the test, subjective awareness is regarded as a sine qua non
yes,
to qualify for general damages. Now, I've already said that the test is slightly differently worded, but the net result is
it compensates
so
the injured person.
yes. So no awareness, subjective awareness of loss results in no general damages. So the court does not even consider general damages because you are not aware according to the finding. Our proposal is that awareness, subjective awareness, and the ability to demonstrate some functional use for monetary award cannot operate as a prerequisite to the legal recognition of the loss of amenities. So the development is, it can't be a prerequisite, but it can be a factor to be considered.
Right.
Subject
how
to
would-
not
how
further
would- How would
differentiating.
the principle, how would the approach be? How would it work practically? What would we be looking for?
Practically, it would play out as it played out in the court of first instance, where a judge is provided with the medical records and the evidence and argument is being made, and the judge considers all of the factors. All of these factors that is placed before the court, all of that record was also placed before the court of first instance, and the court judicially considered it and arrived at the figure of 2.2 million rand, which the court found to be just and fair. But that is the manner in which we propose this is to be done. But you cannot make the awareness, the subjective awareness, a prerequisite to even enter the realm of non-patrimonial damages.
And then what would be at the heart of the distinction between general damages and special damages?
The general damages is a monetary compensation for actual loss. It is determined by asking yourself, what is, as a result of the negligence, what is the additional expenditure that this individual will incur during his lifetime? And you quantify that, and you attach a value to it.
It seems to me that then that principle is recognizes it's for the benefit of the injured person.
It does not compensate loss. It compensates additional future expenditure.
Okay, that's
That is
special
your,
damages.
that's your special damages.
Yes.
It does not compensate the loss. It compensates the additional expenditure that an individual will incur in his lifetime as a result of the injury.
Yeah, and I'm trying to assess that on your principle, how the personality of general damages would work out. In other words, the injured person is compensated generally for the loss, the injury to them specifically. It's to their benefit.
Yes. The exclusive benefit
Yes.
that was advanced, I do believe, is it's the impossible. Because now the court finds that this child is in a vegetative state. So and I thought to myself, what can I think of that one can do to his exclusive benefit?
Yes, if it's not for...
It's a circular argument because there is no such thing.
Yeah, if it's not for the child's or the injured person's exclusive benefit, whose benefit is it for?
But if we ask the benefit, we are moving to the functionality. And that is what Justice Willis in NK in the cause of matters said as well. The court should not look at the functionality of what it is to be used for. This is a payment for amenities lost. It might serve no function.
Perhaps a different way of approaching this inquiry is looking at, if your approach is, the court should not be looking at what the functionality is. How then do we frame the developed principle or the developed approach? What is it?
The developed approach would be that the court is not judicially barred from considering and determining general damages because of a lack of subjective awareness. In determining general damages, as has been pronounced in many a matter, a court and a judge is given a wide discretion to consider everything and anything relevant in arriving at a just and equitable figure to compensate not expenses, but to compensate the loss of amenities.
And then don't we risk commodifying that loss if it's not exclusive to the person, the injured person?
Again, I cannot think of something that you would do which would by implication always be to the exclusive benefit of a person, especially if you, let's take a wheelchair for instance. You buy somebody a wheelchair. That wheelchair you can say is to the benefit of the injured party in that it affords him more mobility or her more mobility. But it is also to the benefit of the person that has to move him. It's easier than carrying him.
That's exactly what I'm saying.
So the exclusive benefit tail or angle to that argument, I cannot think of something which would normally be exclusively to the benefit of an individual in this context.
Yeah, so third parties, it would be to the benefit of third parties as well. In other words, could be to my benefit as the person who experiences perceives the injury.
If we look at the present matter and we look at something like, for instance, a hoisting system. Now, he was provided with a hoisting system because he was too big for his mother to pick up. So you'd put a hoisting system above the bath, and you would hoist him up and you would place him in the bath and wash him. Now, to whose benefit is that? It's to his benefit because he is cleaned, he's taking a bath, but it's also to the mother's benefit. And there are many things that you can say is to the benefit of more than one person, but to say that general damages must be to the exclusive benefit of the victim, coupled with the finding of non-awareness.
Yeah, my problem is,
it's circular.
Or let me not say my problem. What I'm not quite working out practically then is the other person other than him or her, the injured person, to whose benefit the general damages are. Does that mean that any third person has a claim, is a potential plaintiff?
No, I do not.
I'm trying to work out what's the range of the developed principle.
The range of the developed rule is no different from the current range. And let's look at this matter. There's, and we quote in our heads of argument, various other matters where courts dealt with plaintiffs or with children in similar positions, where courts expressed there's no awareness, and still they were afforded general damages. Cases of this type of nature, where the courts actually decline general damages due to a lack of awareness, are very few and far between. So all we are proposing is, let's get back to the basic principles of general damages and let judges consider amounts having regard to anything that they judicially can do so, obviously subject to not discriminating any further. But that is our argument in totality is aimed at uplifting or removing the legal obstacle to qualifying for general damages. You cannot place this obstacle there. You can consider it, again, subject to what Justice Colopin also pointed out, not discriminating, but that is where it belongs. And that is exactly what the Court of First Instance did in the present matter.
Should a distinction be drawn between the situation where the patient is responsive and the situation where a person is unresponsive? In responsive, and I read what Woburg said about that, he said, yes, obviously where a person is aware of the extent of his or her loss, then that may give rise to a very substantial award. My point is those considerations cannot be taken into account with an unresponsive person because that person cannot respond or display an awareness of the situation in which he or she is. But should that then diminish the award of damages, or should that person be entitled to exactly the same as a person who is able to express his or her awareness of the position he or she is?
Justice Basol, I must profess, and during the discussion I had with Justice Colopin as well, Justice Colopin pointed this out and it became evident to me. It's not necessarily something that I specifically considered, but it is now being debated. And I agree. I agree that the lack of awareness should not be used in a manner that differentiates between one individual and the next. I accept that. But I also accept that general damages has a personality element. That I also accept. And my proposition and argument is that we should leave it to judges and to courts to decide matters and exercise their discretion considering everything, and obviously refraining from taking a certain category and discriminating against an individual.
does that not bring us to the point where the emphasis should be objectively on the injury itself and not on the compensatory aspect
I accept.
flowing from that injury?
That I accept. And Justice Basson, again, if we look at what is happening in the courts out there, I think that is to a large extent how general damages is being applied at the moment. We have a system where continuous judgments are made on paper, having regard to, well, that's the nature of the injury, to be a fibula fracture, so that is value X. So to a large extent, I believe it might be due to overload and workload and the amount of cases, but that is how, in practice, it is being applied to a large extent. So determine the loss, look at the loss, and compensate that.
And the same can be said when one deals with pain and suffering. Apart from the fact it's very difficult to pinpoint whether or not a person suffers from pain or not. And I think it's Boberg again that says there could be some kind of a residual consciousness, but leaving aside the whole awareness element, and one should also bear in mind that an unresponsive person cannot always convey that he or she is in pain. So would it not be advisable then to also just concentrate on the objective nature of the injury and take into account that this injury has destroyed this person's entire life?
Justice Basson, I'm inclined to agree that such an approach will result in the best judicial certainty in approach and would result in differentiation, possible discrimination being eliminated from the equation. I accept that.
Thank you, Acting Deputy Chief Justice. Advocate Myberg, can I just explore some of the questions that I think Justice Matopo began, and he said he didn't have the time. So I have the time. Isn't the problem that the entire structure of the argument of the government premised on some sort of a special recognition of mental awareness rather than the fact of being alive? And in a sense, that's a reflective of the general discrimination, and I think that's what the second amici says. That's reflective of the embedded discrimination against mentally disabled persons, because there's some premium to this idea of being mentally conscious as opposed to putting a premium on the idea of being a person.
I accept. I accept also that we can have lengthy debates and discussions, probably philosophical and more technical in some instances, regarding the authority that brought us to where we are. And we can have a debate regarding the Collins judgment, and we can juxtapose that to the NK, or the Causa judgment by Justice Willis, and how this approach developed. But in principle, what the SCA did is to say that this is the test. Why? Because it's always been like this.
Yes.
That is in essence.
Yes, but I mean, doesn't the constitutional structure require us to place emphasis on the fact of being a human?
Yes.
Yes.
Justice Nkaitobi, I'm going to be blunt. We cannot allow a Supreme Court of Appeal judgment to stand which calls a child who is severely mentally disabled equal to dead.
Well, I mean, that
It
comes from the
affronts.
Collins judgment. That was the judgment of Judge Scott, that a severely mentally disabled person is equivalent to dead. And regrettably, it's also at the heart of the SCA judgment. In fact, it's not at the heart of the judgment, it's expressly there.
Yes.
Now, that's why I'm asking whether, isn't the problem really that the entire structure is premised from a discriminatory departure point?
Yes.
And that's fundamentally inconsistent with the Constitution.
I have the utmost confidence in making the submission that the approach that was adopted is ignorant of the constitutional principles of dignity,
Yes.
of equality, and the underlying principles of how our law developed to treat and recognize disabled individuals, yes, but more importantly, people. Look how far we've come in recognizing the inherent worth of everybody, of being a human. And I find myself, as I said in my opening remarks, juxtaposing Mr. Makwanyane against this child. And I look at that treatment and I look at this treatment. And I can categorically state that this treatment of this child does not align with the constitutional principles enunciated and enforced by this court in Makwanyane.
I've got a couple of other questions. I just want to make sure that I don't fall foul with this acting Deputy Chief Justice's plan about tea. Should I continue? Yes, thank you. The next point I would like to explore with you is why you accept that there is a common law rule in this case. From the judgments of the SCA, there are three judgments on this point. The first case was Gerke in 1966. The next case was Reineke, and the last 1991, and the last case was Collins in 1995. Reineke and Gerke are aligned, although there are nuances, and Collins departs from them. Why is that the common law?
Justice Gauteng, what I can safely say, and again, I had to be very attentive to what invokes the jurisdiction of this court. But what I'm confident to say that subsequent to the handing down of the majority judgment in this matter by the SCA, that has established the common law. So following that judgment, I do not want to be heard to say that the court erred in applying the law. I'm careful to tread there. I'm confident and comfortable to make the submission that following the judgment of the SCA in this matter, the common law principle has now been clarified as to what they pronounced.
Yes, that's the point I'm driving towards. What has happened here is that the SCA has formulated a new rule, not based on any previous body of law. And that new rule is coming to this court to decide whether it's correct or inconsistent with the Constitution. So we are in exactly the same position as the SCA to develop the content of the rule.
That is correct.
But we do so with the Constitution in mind. Yes.
As I said, the word dignity appears once in the entire judgment. And I think that is indicative of where, in my submission, the constitutional infusion was missed. It's evidence of that, at least.
But you would accept that prior to the statement of the law by the SCA, there can be no common law on this topic flowing from Gerke, Reineke, and Collins.
Justice Ngatobe, I will accept that there were conflicting authority.
Indeed.
That's the very best. Gerke, Reineke on the one side, and Collins on the other side. And the Supreme Court of Appeal, having regard to the history of this claims in general, preferred the methodology pronounced by Justice Scott in Collins, yes.
Yes, but those three judgments cannot be said to constitute a body of the common law.
I accept.
Yes. Now, then, the next thing is what you accepted in your argument, which I have a little bit of a difficulty with, which is when you look at general damages and you split general damages to loss of amenities as well as pain and suffering. And you seem to accept that for pain and suffering, the mental awareness would be a sine qua non. Did I get you right there?
No, I accept that it might, if there is no awareness of it.
Why?
It might result in...
Why?
Justice Nkatobi, that was the view I held.
No, but I'm asking, why should this court...
But I'm the first to accept that in my interaction with Justice Colopin and Justice Passon, it became evident to me that what I'm what I've proposed and what I concede in that regard might create further loopholes and further difficulties and further differentiations. I'm fully prepared to accept that. And in developing my argument to this court, I accepted that subjective awareness of pain and suffering will impact or might impact on the amount you are awarded for it.
Yes, no, I understand. But your current argument now, forget about what you said earlier, is that mental awareness for pain and suffering is not a sine qua non.
No.
Yes.
And that is the crux of my entire argument, is there can be no sine qua non for general damages, to qualify for general damages. You can consider various factors and exercise your discretion, but you cannot elevate any of those factors to a sine qua non to qualify for it.
Yes.
That is the crux of what I am arguing, and that is what the crux of why we say that the rule, whether it enforced or created by the SCA, is constitutionally invalid.
Yes. Now, if your argument is that it's a factor but not a sine qua non, the difficulty still arises as to what weight is given to that factor and whether or not it does not again privilege mental awareness and proceeds from the discriminatory premise that there's something wrong with being mentally disabled.
Justice Nkatobe, I will concede that the best manner in which to evolve and to adapt this whole legal concept is to actually to remove the subjectiveness entirely from it.
Yes, certainly insofar as the determination of the entitlement is concerned. Quantum, what would you say on quantum? Because what I understand from Gerke and Reineke is that mental awareness remained a component of the determination of the quantum. So if we're removing it from an entitlement, do we still keep it on quantum or we remove it entirely?
Again, I believe it would be appropriate, and then again, this is subject to not any of the factors being used to unfairly differentiate. I believe it would be appropriate, having regard to general damages and the nature of it, to afford a judge awarding it to consider as many a factor which is relevant as possible. But none of those factors can be used as a qualifying factor, can be elevated to a sine qua non, and none can be used in order to differentiate and subsequently discriminate.
Sorry, Mr. Myburgh, I don't want a vague argument. I'm dealing specifically with mental awareness. Should it be removed entirely in the assessment of quantum or not?
Yes.
Yes. Thank you, District.
Thank you, Mr. Myburgh. Following on my colleague, Acting Justice Nkatobe, it's been more than 25 years since the former Chief Justice, Justice Chaskelson, cautioned that we had one system of law, and that was a system in which the Constitution was the supreme law. And it seems to me that when we speak about the development of the common law, we must speak of a development which, in terms of Section 39(2), gives effect and meaning to the Constitution. And the rights to which you've referred are inter alia dignity, but they also are the rights of the child under 28(2), the best interests of the child, and of course the right to life. And it seems to me that mental appreciation of a constitutional harm which you have suffered, a loss which has been suffered by a person, must be given proper recognition in our law, in whichever way we do that. And that whether a person appreciates that loss or whether the usefulness of any salatium to a particular person is not a relevant consideration. But what would you say to that?
Justice Savage, I would accept that in compensating this minor child, whether he knows it or not is irrelevant. The because we know it, we see it. We value him as a human being, as actually a young boy. And objectively, you can look at it and you can see the loss. It's not hidden. It's there for all to see.
So then you move away from the suggestion that, in fact, one must inquire into whether there was a subjective appreciation of the loss that had been suffered.
Justice Savage, I'm mindful. I'm mindful in arguing, if we accept that the SCA pronounced on the matter and that constitutes the clarified common law position. I am mindful of the warnings judicially issued that developments should be incremental. I am mindful of that. And in preparing my argument, I was mindful of not deviating too much so that I can comfortably state that the development we are proposing is incremental. What I'm also more than willing to concede is that the relevance and the role that the subjective awareness is playing creates legal and constitutional difficulties. I'm more than prepared to accept that as a proposition. And insofar as it would constitute incremental development, and we can exclude that, to elevate and to give effect to the principles of the Constitution and the values that we attach. If we can do so, objectively speaking, that would be the correct course of action. So the more we can minimize the subjective role, the more we will create legal certainty, and the more we will give effect to the principles and the spirit and the purport of the Bill of Rights, yes.
Of course, this case once again reminds us of the dangers of childbirth for women and also for children, particularly born in the public health system. And it seems to me that that's another factor which came to bear in this matter, that this minor child may not have suffered what came to pass had he not been exposed to those societal dangers which are created by a public health care system which simply does not accord with what constitutionally is required in terms of access to proper health care.
Justice Savage, as the council that dealt with this matter since 2019, I can categorically agree that what we see in those photographs and what he suffered is as a direct result of substandard care rendered to him and his mother.
So if we agree on all of this, then what development of the common law? There's a common law principle which allows for general damages to be awarded. What is the development that you are seeking?
Is, and again, I'm accepting the pronouncement of the majority of the SCA as the recordal of the current position, and that is that subjective awareness constitutes a sine qua non to be even considered for general damages on pain and suffering, and effectively, technically, it's also a bar against the loss of amenities.
But what if that is a legal error that simply doesn't reflect the accepted legal position? In fact, there were 3 judgments, as Judge Nkatobi indicated, 2 of which went one way and the other, on which the SCA relied, in fact went the other.
If that is a legal error, that is so. But
then is there a need for the development of the common law?
I accept, Justice Savage. But again, I was mindful of what is required in order to invoke the jurisdiction of this court.
Well, it seems to me that we need to infuse the common law far more readily with constitutional values, rather than, and to the extent that we seek the development of the common law, that's the development that needs to be sought.
I accept.
Thank you.
I accept that.
Mr. Mybeck, just on the issue that Justice Nkatobi raised, I had understood the applicant's case to only concern the issue of loss of amenities of life and the acceptance that in relation to pain and suffering, there is no development that is required. Did I misunderstand the applicant's case?
Justice Nuku, the argument being advanced.
No, just the applicant's case.
Yes, the applicant's case is that you cannot elevate subjective awareness to it becoming a legal bar against being awarded general damages.
No, you're making an argument now. All I'm trying to get from is clarity
I initially,
on
and
the applicant's case that the respondent came to meet.
the applicant's case is that the rule that you make subjective awareness a sine qua non in order to qualify for general damages. Whether that be on pain and suffering, whether that be on loss of amenities, that elevation to a sine qua non does not align with constitutional values, especially having regard to the manner in which the Supreme Court did it.
All right, so the short answer is
So-
that in respect of both pain and suffering.
I initially started my argument with accepting that subjective awareness will be a relevant consideration in determining the actual value of general damages, the just and fair amount. But in my interaction with Justice Mkaitobi, with Justice Basson, it became evident, also Justice Colliper, that also carries with it the inherent problem of further discrimination, further differentiation, and further constitutional problems. And I am prepared to submit that the removal of the subjective element of awareness in the entire consideration and determination would create more legal certainty, and it would result in a more fair treatment of all individuals before court, yes.
But now, how does that change impact on the case that the respondent came here to meet? Because it seemed to me that there was no dispute between the parties as to the relevance of the subjective awareness of pain, in relation at least to pain and suffering.
I'm fairly confident that Mr. Rousseau and his team prepared a case to say that the SCA is right.
No, well, I'm
And we said
asking
the SCA is right.
this in the context that the courts are required to determine disputes that have been advanced by the litigants. The litigants have a choice of what case to advance.
Yes.
And when you advance a case, then your opponent knows that this is the case that I must meet, and the court must determine that case.
Justice Nuku, again, I've refrained from going there, but I think it's important to point out that the final judgment pronounced by the Supreme Court of Appeal also did not align with the argument advanced by the MEC. The initial argument advanced by the MEC in court of first instance is that the compensation payable should be limited, and that is also the argument that they advanced. So there's always been a concession by the MEC that this minor qualified for general damages. It's just that they argued a far lesser amount, and the Supreme Court of Appeal decided to reject that proposition as well and to move to a total denial of general damages. But similarly, the MEC as well did not argue zero. But my submission is that the arguments we're being made and the role that should be given to subjective awareness aligns fully with the argument that we've made, with the edge that we've argued. So I do not think that my learned colleague, far more experienced counsel than me, will be unduly surprised by this. That is the rule that we are attacking, the rule as pronounced by the Supreme Court judgment and the majority thereof.
Sorry, DCJ, just on this last point. Does this make any difference? Because the particulars of claim, I think it was paragraph 15, didn't draw a distinction under the general damages between an amount for pain and suffering and an amount for loss of amenities. They just claimed 5 million rands for all of those subcategories. Similarly, the award we are dealing with here for 2 million rands didn't draw a distinction between pain and suffering and loss of amenities. So if you remove the subjective awareness, it actually makes no difference to the case.
That is correct, Justice Mkopi.
Sorry, I just need to get clarity on one last issue. In our interactions, in your interactions with the bench, we located it understandably in the context of this case, in an understanding that Craig feels pain. Whether he's mentally aware of that, but he feels pain and the discomfort and something unpleasant happening to his body. And that's evidenced by his reactions. you've accepted now that mental awareness shouldn't be a factor at all in both parts of the rule. My question to you is whether the subjective experience of pain still is relevant. And I ask this in the context of someone who's in a coma. They will not feel pain. They wouldn't be mentally aware of it, but they would not feel it either. Would such a person be entitled to damages on the basis that the feeling of pain is part of the mental awareness? Or can one distinguish those cases? Or is that not the business of this court in this case? That might be the easier answer, but I'm not sure if it's the right answer.
Justice Collipin, I'm going to make the liberty of stating something which is not necessarily on the record, but I recently...
As you answer my question.
Yes.
Yeah.
I recently dealt with a matter in which a 9-year-old boy developed thrombosis. He suffered injuries, and as a result, his left hand became contracted like that. Now, these contractions you see on the current mine in all his limbs. And he asked in hospital in Sunninghill, he actually asked one of the doctors if they could please cut off his arm. That's how much his hand was hurting. And you think, you take that and you look at these children, and you look at the contractures of their bodies. And again, I'm not in a position, and nobody is in a position, to say what exactly he's experiencing. Objectively speaking, he's being tortured. What is lacking only is the ability to communicate, the ability to convey the experience. That is all that is lacking. But we cannot objectively say that a child that suffers epileptic seizures 8 per day, that dislocates his hips, it must hurt. His inability to tell us he does.
But are you saying that we must accept the proposition that someone who's in a deeply comatose state, the only shortcoming there is an inability to communicate, but that person may well feel pain? That's quite a far-reaching proposition, is it not?
Again, in a comatose state, I would say that it's dependent on the medication being received. I think to a large extent you can actually disqualify some of those individuals of having experienced pain.
But maybe we're not dealing with that in this case, and maybe that shouldn't be our business. Yeah. Okay.
Thank you, Mr. Maybach. We'll take a tea adjournment, 20 minutes, and come back at 12:15. Yeah, Lily, we gotta go. Yo, the pala TV, the magazine. I Natasha. Oh, I know. I thought we wanted to take my to the party.
Afternoon, everyone. Let's get ready. And please, no food are allowed inside the court.
Please rise for the Constitutional Court.
Yes.
So we make two attacks in our heads of argument. The first is what we call the false equivalence, which is the issue that came up earlier. And then the second is the dignity attack. If I can just start, I believe I can be quick, with the false equivalence.
Please raise your voice or come closer to the mic.
I'm sorry, if I can start with the false equivalence. What we say is that the majority in the court are quo equated unconsciousness in a legal sense with a lack of intellectual awareness of what's happening. And that you will find in paragraph 71 to 73 of the judgment. Justices, that was a seismic shift in the law. You won't find any case. You won't find any case, no matter how long you look, in South African law, which equates unconsciousness with a lack of intellectual awareness. We say it was unjustified, it was illogical, it was unprecedented, and it wasn't thought through. And you'll have seen we make the point in our heads of argument, and it has been made, I think, by Justice Matopo, that there are passages in the majority judgment that unequivocally acknowledge the pain and the suffering of the child. But then because of the definition which they arrived at of unconsciousness, without anywhere investigating whether that's ever been part of our law, they arrived at the wrong conclusion. And I've got no difficulty in suggesting that this fundamental misdirection, the false equivalence, engages the jurisdiction of this court. It's clearly an issue of general public importance, which ought to be reconsidered, and there can be no doubt it also engages constitutional issues. So that's our first point. And I suppose this court could, if it's with us on that, could just stop there, because that would lead to reversal. Because when we argue this case, when we get to the dignity question, there's a bit of a dichotomy, because we argue the dignity question as if this child was unconscious, when he most certainly wasn't. But I would suggest that the court must go further and must correct or must address the unconsciousness issue. So if we were to assume for present purposes that this child was truly unconscious, was in a coma, a permanent vegetative state, here is where we respectfully and affectionately depart from the applicant, because the applicant says that the common law needs to be developed. We honestly don't believe so. We believe that this issue of whether general damages should be awarded to an unconscious claimant, not this child, but an unconscious claimant, the common law has always been pregnant with that question. And the reason for that, as we've shown in our heads, is because the common law action for pain and suffering, as it developed, there was always a question: are we dealing with satisfaction or are we dealing with compensation? And one will find that in the text. It's in our heads. And arguably, if we're dealing with satisfaction, well then, the fact that this person is unaware might mean that there's no general damages. If we're dealing with compensation, the fact that this person is unaware might influence the quantum, but not the question of whether. Bailey, as we've shown in our heads, Bailey actually did away with that, because Bailey said, we simply look at the circumstances and award compensation. And Gerke and Reineke arrived at the right conclusion, even leaving the Constitution aside. And Collins, which was a post-constitutional decision, arrived at the wrong conclusion, even leaving the Constitution aside, but most certainly, in light of the Constitution and the value of human dignity. And I'm not sure there's much more I need to say. I've heard the debate about awareness. I don't know if it's for me to weigh in on that, so I won't unless I'm asked to. But we suggest that the situation is plain. The majority in the SCA got it wrong. It got the common law wrong. It most certainly got the common law wrong in light of the Constitution, and therefore the case must be righted. Thank you.
Just one question from you. What is your submission on how the interests of the child should influence this court's determination when it comes to this question of the common law position for general damages?
Justice Bushland, this question came up in our discussions in preparation, and I kept saying, I don't think this case even goes that far. The majority's decision is so plainly wrong in terms of the common law that we don't need to go that far, but it's one of the things they got wrong. They didn't value the child, but we don't even have to go that far, because our common law, since Bailey, has resolved that it's a mix of objective and subjective. It's a matter of looking at the reality of what's happened and then fixing compensation.
Can I just ask you something maybe quite abstract, but perhaps you may try to respond. Does the inability to communicate pain establish absence of pain, or is merely the evidence that cannot, or it's merely the evidence of absence of pain?
Thanks, Justice Matopo. You might have seen in our heads we took one through the cases, and you'll have seen that in the cases, some of the cases dealing with unconscious claimants did actually bring out the question of when do people suffer pain, and there was a case where an unconscious, and when I say unconscious, I mean properly unconscious, an unconscious claimant would groan in his unconsciousness. And the suggestion was that shows he's suffering pain. And the medical answer was apparently no, the groans relate to something other than pain. I think the answer to it is this. It seems to me that the law must compensate for what happened. If on the evidence the person is suffering pain, the law must compensate for that pain, but it must compensate for other things, the loss of amenities, the indignity, etc. But if we come to the question of pain, you should only be compensated for pain if you're suffering from pain, and whether you're suffering from pain or not would be a matter of the evidence. Does that answer the question?
Well, the second one would be, should the fact that the patients may subjectively not communicate that pain be held against that patient in the purpose of the assessment?
Again, can I answer that question just with reference to my own experience? I've had a case of somebody who it was argued was in a permanent vegetative state, and I knew he wasn't because I had spoken to him and he'd responded. And yet the evidence was he's a permanent vegetative state, and the test for that, apparently, is you put a blanket over his head, and if he doesn't respond, then he's PVS. I knew he wasn't, and it transpired that we could show that if any stranger came towards him, like a doctor examining him, if they put a blanket over his head, he did nothing. But as soon as he was back to the people he knows, his family, his nurses, he responded as best he could. I don't know if that's the answer to the question.
Well,
Because-
it does if one does not
Can I interrupt?
take away the fact, the objective in DKI about the condition of the minor child and the responses which the mother reports, as well as the medical evidence insofar as her responsiveness to the surroundings that he found himself in.
So if I could interrupt quickly, I suppose my answer is whether somebody is suffering from pain would depend on the evidence, but I think that we should always be very careful before we easily arrive at the conclusion that because they can't communicate something, they aren't suffering it.
So this, in essence, you are saying this intellectual awareness that has been bandied around in the judgment of the SCA, it's a tricky and a wild horse to ride.
Here's my stance. That intellectual awareness has nothing to do with the question of unconsciousness. And so they were wrong about that. And the question with which the common law was pregnant of whether an unconscious claimant who is unconscious of their loss should receive general damages wasn't triggered by the case. Once we get that out of the way, I do believe that the law should have regard to the degree of awareness in compensating. I heard the questions and I've heard the debate. It just seems to me that if you get two people, one of whom is, as a result of the same injuries, blissfully unaware of his situation, and the other of whom is in a state of total constant mental anguish because of his situation, the latter is worse off than the former. And I wouldn't think that our law could possibly treat them as the same. They're both entitled to general damages, but the one is, ironically, less affected than the other is. And I speak from experience too. I've always said the worst injuries I ever see are people who are trapped by their brain damage in this unworkable body and who cannot speak and yet scream their anguish. They're worse off. They're worse off for that. So I think the law must have regard when it looks at the amount of compensation, at the human differences.
Finally, what do you say to, what's the right word? The travels or the forays of the SCA in going to foreign jurisdictions in an effort to show those foreign jurisdictions how they have approached this issue and attempting to answer the question. Would you say the foreign jurisdictions were helpful or misdirected the SCA?
I think it's perfectly permissible because, as I say, this was a question with which our common law was pregnant, and they addressed it in a case that wasn't appropriate to it because the child wasn't unconscious. I think from Bailey onwards, we actually knew what the answer is. The answer is this is not a matter of satisfaction, it's a matter of compensation, and you take the person as you find them. If they're not suffering pain, then you don't compensate them for the pain they're not suffering, but you compensate them for the anguish they might be suffering. And even if they're unconscious, you still compensate them as a society for the loss of dignity, etc., that goes with it. And I can see no difficulty with the majorities going overseas to see how have courts overseas answered the question, but always it must be anchored back in South Africa. And if they had anchored it back in South Africa, forgetting for the moment the fact that that child wasn't even unconscious, if they had anchored it back in South Africa and they had looked at the cases, they would have realized, with respect, that Gerke and Reyneke were in line with Bailey and Collins wasn't.
Well, insofar as the constitutional provisions are concerned, Section 10 of the right to dignity, this is what the SCA said in paragraph 147. It says, I'm going to read it out to you, you must have seen it. In addition to the above general contentions, counsel for the respondent asserted that denying the child damages for loss of amenities of life would result in a breach of his constitutional right to dignity. And the response, it said, there is no merit to this submission, and that was the end.
We dealt with that in our heads. I mean, they didn't engage the question. They simply rejected the question, and they were wrong, with all due respect.
Okay, thank you.
Question on the appreciation of the lack of intellectual appreciation. At para 72, that's where the SCA came up with this concept, which appears to me to be an introduction of an element, a new element for general damages. Would that be development of the common law or what? Or an extension of what would be required?
They did develop the common law without realizing they were developing, and I say that with respect, the common law, without saying that they were developing the common law. What they did is they equated this young boy with an unconscious claimant and then proceeded on the assumption that he was unconscious. So once we forget about the fact that they did wrong to start with, then they decided that they had a choice between Gerke and Reyneke on the one hand and Collins on the other hand, and they simply concluded that Collins was wrong. You'll have seen in our heads we criticize the reasoning. We say on that reasoning, a young baby of 3 months old apparently wouldn't be compensated with general damages if you burn that baby. And we know how terribly the baby would suffer. Why? Because the baby doesn't yet have intellectual awareness of the fact that it's being burnt. It just doesn't make any sense. I don't know if I'm answering the question, but I'd rather simply say they got it wrong.
Yes. Thank you.
Thank you, Mr. Mullins. If you're saying the point of departure is that we should conclude that Craig was a conscious claimant as opposed to an unconscious claimant, then the essays treating him as an unconscious claimant, well, was incorrect. But then whatever they say with regard to the law that should apply to an unconscious claimant, how should we deal with that if we accept your invitation to consider him to be a conscious claimant? Then the way in which they develop the law is in respect of an unconscious claimant, not so.
Correct. But they did purport to develop the law in respect of unconscious claimants.
Of a conscious claimant?
Well, unconscious because they regarded him as safe.
Sure, but if he's not unconscious and if we are with you, then...
So Justice Collipin, say if one leaves the decision as it stands and simply says, well, they got it wrong about consciousness, then that case will still guide all courts
in the future
in cases of unconsciousness. The common law has been pregnant with this problem. It's come up here, shouldn't have, but it did. It should be addressed now, and it's clear how it should be addressed.
Okay, thank you. And my second question is that given the nature of the condition Craig suffered was degenerative, and it gets worse over time, that it becomes quite difficult if one reads the literature as well as the reports to sort of develop these kind of neat pigeonholes into which one would slot a particular condition. And therefore, language like the twilight zone, etc., I didn't find particularly helpful, as opposed to answering the question, was there consciousness, was there awareness, something like that. And I'm also more cynical about some of the experts views when I hear your startling example of the blanket test. It almost reminds one of the tests that was used in the Middle Ages to determine whether a woman was a witch or not. They tie her with stones and they throw her into a pond. If she survived, she was a witch and then she'd be burnt at the stake. Well, if she didn't survive, well, she wasn't a witch, but then sorry about that. So would you say that it might be better to steer clear of, in a sense, those categories or what?
Can I just quickly take up time? What happened in that case, there was a wonderful neurosurgeon who flew up to see Batu and put the blanket over his head, no response, and then he tiptoed out. And so he walked out loudly, and then he tiptoed back in, hid behind a curtain, and then he saw the interaction between Batu and the people around him. So it shows you we should be hesitant to arrive at quick conclusions. I think I've lost the drift of the question, but
My question was simply that we should avoid, where possible, sort of these straitjacketing, maybe that's even the wrong term, these categories. Yeah. I mean, there is language that's wakeful, unresponsive syndrome and stuff like that.
Yes and no, and we've said in our heads of argument, we think, obviously the issue of twilight moments would become important if we allowed the SCA decision to stand, because then twilight moments would be the difference between being compensated for general damages or not. But as soon as we don't let it stand, twilight moments either are there or they aren't there. It's just a factor of the totality.
Thank you, ADCJ. Mr. Bullens, can I just understand, if the complaint that you identify is the misinterpretation of the medical evidence, that the SCA thought that consciousness and subjective awareness are one and the same thing, is that the question that you say is before the court?
Yes, because there was a legal conclusion at which they arrived. It wasn't factual. It wasn't factual. It's not as if they said in the evidence there is no pain and they got that wrong. They arrived at
all of those are about the misinterpretation of the medical evidence. What is the legal question?
The legal question is, does that evidence of that degree of pain equate to unconsciousness? That was a legal conclusion. So the legal conclusion is that you're unconscious unless you have intellectual awareness. That's not a factual question. The factual question would be whether you have the intellectual awareness. The legal question is their conclusion that if you don't have intellectual awareness, you are unconscious. That's a legal question. Must be.
Yes. Well, you say it must be as if it's obvious. It's not obvious to me, at least, because they had to interpret the medical evidence. They looked at all of the reports over 3 pages. They ultimately say that these reports show lack of consciousness.
With respect, no. That would be, I'm sorry, I didn't
Sorry,
mean to interrupt.
what is the no part?
The no part is they interpreted the evidence. They said he suffers pain. They said he has a horrible life. I think they used even that term. And then they said that equates to being unconscious in law. That's a legal conclusion.
Well, I mean, that's not unclear to me because I see consciousness and awareness both as medical terms. But you seem to suggest that consciousness is a legal term and awareness is a clinical term. I really find it difficult to grasp what the legal question is if you are saying the problem is the misinterpretation of the medical evidence.
The legal question would be whether a person, whether it be a child or not, who suffers pain and suffers loss, but has no intellectual awareness of that loss, is unconscious for purposes of the law. If, for example, this appeal related to whether the evidence had justified a finding that the child suffered no pain, that would be factual. But that's not the issue. There was no factual dispute. They simply arrived at the conclusion that to be conscious for purposes of the law, to qualify for a general damages award, you must have intellectual awareness. And that surely is a legal question.
Yeah, certainly my own reading of the judgment was that the consciousness followed from their analysis of the medical reports. And you can see that from various passages in the judgment, but more pertinently from paragraph 61, because there they start by asking, is the child in an unconscious state? Then they refer to the leading authority on the subject, Dr. Fred Plum. Then they look at the reports of the neurologist, Dr. Kashave, Dr. Mukhashwa, Dr. Levine, and Dr. van der Reist. And then at paragraph 71, they say that what is the conclusion. And then it's on that basis then they come to paragraph 74, where they say what remains to be determined is whether the child, as an unconscious claimant, is entitled to be compensated at all for loss of amenities of life. But the unconsciousness is a medical conclusion which the counsel for the applicant warned us leads to arbitrary outcomes when judges try to understand what the doctors are saying.
Yes, I would suggest not. I didn't find in the judgment anywhere where in arriving at their own conclusion of unconsciousness, they relied on the expert evidence. They relied on the expert evidence to tell them about the condition of this child. And because that expert evidence told them that the condition of this child is that he has no intellectual awareness of his pain and suffering, they arrived at the legal conclusion that that means he's unconscious for purposes of the law.
Now, I hear what you're saying. I'm struggling to understand why you say the SCA's error is one of law when it seems that they got to the conclusion of unconsciousness based on their analysis of the medical evidence, which they then said shows that this child is not intellectually aware. And they clinically interpret that to mean he's not conscious.
With respect, no, they legally interpreted that to mean he's not conscious.
Yes.
I don't find anywhere in the judgment where they deal with the experts dealing with unconsciousness or consciousness. They deal with what the experts say, and then they say he has no intellectual awareness, and then they arrive at the
This is
legal
the whole problem I have with your submission. But anyway, I think you've said what you could say on that topic. Are you going to say anything else about the dignity part, which is the second part of your argument, on the assumption that the first complaint would not engage the jurisdiction of the court because it would be an interpretation of the medical evidence, and there the SCA can get it wrong, but we are not entitled to interfere?
That would be a sad day if that were to be the court's conclusion, but then we would rescue it on the dignity point.
That's what I wanted to hear. What are the submissions there?
Yeah. The submission would be this: if this court feels bound to accept that it cannot interfere with the finding that this child was unconscious, well then legally the court got it wrong, because if this child had been unconscious, this child was still entitled to general damages, because the majority failed to give any value to the dignity of this young child.
I mean, as I understand, you actually agree with the government that subjective awareness is a relevant factor in the determination of the entitlement to general damages.
No, with respect, I must have made myself horribly unclear. We agree with the department that awareness is a factor in the quantification of the damages, but it is not a factor in the qualification in order to be awarded general damages. Most certainly not.
Yes. Now, in the quantification of damages, what role does subjective mental awareness play?
Quantification is a matter of assessing what is and what would have been, and then doing your best to place a monetary value on that difference. And to the extent that the claimant is unaware, that is a mercy which a claimant who is aware isn't spared. It is a difference between them. And one can turn it around. It wouldn't be right, to my mind, to give an unconscious claimant who is unaware of his loss the same general damages as you give a conscious claimant who is aware of his loss, because the latter is worse.
I mean, why is that so? Because it strikes me that what you are suggesting is that we must entrench the discrimination against medically or, let's say, disabled persons, because we treat this mental awareness as some sort of a special thing to override the mere fact of being alive.
As I stand here, I can feel I should be agreeing with you. But as a lawyer who is proud of the law and the logic of the law, I just find myself unable to. As far as I'm concerned, compensation has to do with the realities confronting the judge. And if the realities confronting the judge are that this one is saved from awareness, and that one is in constant mental anguish because of awareness,
Yes,
that one must get more.
Yes, well, I would have assumed that everyone who's sitting in this room and talking is a lawyer. But what we are engaging upon is what is the content of the law. So I'm not sure I follow the distinction you're drawing between agreeing with me but not agreeing with me.
Perhaps I should have said as this lawyer.
I think that's probably more accurate. Do you have anything else to add to the point I'm trying to tease with you? Is why should the Constitution tolerate the distinction that you are proposing?
Because if we were to take that step, then we would of course be developing the law, because the law to date has taken each individual case on its individual merits. And
I have a problem with that. We went through this exercise with the Applicants' Council. There are only 3 judgments that are relevant in this case. One is a 1966 judgment of a single judge in the High Court. Another is a 1991 judgment, a single judge in the High Court. The last one is a Cape judgment, again a single judge. The very first time the courts have a chance to express themselves on this is in this case. So in a sense, we are deciding what the content of the law ought to be. Now, that's why I'm asking you to make submissions on what the Constitution requires the law to be. Does the Constitution tolerate the distinction that you are drawing in agreeing with the government?
Justice, this lawyer suggests that the Constitution does. But this lawyer is aware of the fact that I probably should be agreeing with you, because it would be to the benefit of claimants. But my understanding of the law is that there would be nothing unconstitutional in the laws drawing distinctions between the realities of individual claimants, but I'm perfectly willing to concede I'm wrong.
All right, thank you, ADCJ.
Mr. Mullins, can I just understand? So a baby who got severely burnt but doesn't recognize that the situation that they're in versus a child who got severely burnt would be treated differently in terms of a general damages award?
I'm afraid that wouldn't be correct, because that baby who was burnt will soon realize. But I'm drawing a distinction between somebody who is comatose and somebody who suffered the same brain injury but isn't comatose as a result.
So if somebody's beaten up so badly that they simply don't recognize the extent of their injuries, versus somebody who's beaten up less badly by the same person but recognizes the injuries, the second person would get more than the other. That's what you're suggesting?
If the evidence were to show that the latter suffers extreme mental anguish as a result and the former doesn't, I would think, Justice Savage, that in weighing the two up, I would think one would say that the one with awareness is suffering and will suffer more greatly.
But is this not really on quantification of damages ultimately at the discretion of the judge?
Yes.
And do we really need to go here on the facts of this case?
I don't believe we do. So perhaps that's what I should have said. I don't believe we need to go there.
Mr. Mullins, I just want to understand the nature of the difference that you have with the proposition made by the applicant, by Mr. Mayberg. As I understand the constitutional development argument, it says that there should just be a public acknowledgement of the injury occasioned or the impairment of dignity. And then on the other side, where the injured person is comatose, there shouldn't be no general damages compensation. What problem do you have with this argument? Because it seems to be quite clean and straightforward approach to this distinction between a totally comatose person and the degrees of consciousness.
I might be misunderstanding, but we understand the common law until Collins to have always acknowledged that general damages involves a subjective and an objective component. Subjective means, is he suffering pain? Subjective means, is he experiencing anguish? Is he experiencing mental trauma? And if he isn't suffering any of those, well, then we don't compensate for what's not being suffered. The objective is, but even if he isn't experiencing any of those, he's still a human being with dignity and with value, and so we must compensate for that. I don't know if I'm answering you when I say that.
I'm not sure as well, but I think you're explaining the common law as it is understood presently, and I know you say there's not quite a development, but it's a question of the SCA simply having misunderstood common law. But what I'm putting to you is accepting, let's accept for a moment that there will be development of common law. And where there's no distinction of the various, for determination of general damages, not the quantum, where there shall be no distinction between the various degrees of neurological impairment, but simply a distinction of a totally comatose person, which you say unconscious, and a person who has been injured but still retains even the minimal neurological function, and a public acknowledgement in terms of the constitutional principle that the dignity of this person has been impaired, or they have been injured one way or the other.
Both, again, I hope I'm not misunderstanding, but both in my submission will be entitled to an award for the loss of the amenities and for the indignity that they are suffering, which is objective. But the one who has a or a greater degree of subjective awareness would probably, because every case depends on its own facts, probably be entitled to a greater award because they're suffering more greatly, because that subjective awareness is an element of their suffering.
Okay, but I think that's in reference to the extent of the acknowledgement in determination of quantum. But I suppose that's as far as we can take it. Thanks.
Thank you.
Thank you very much. Mr. Duplessis, am I right? Yes. For the second amicus, Mr. Duplessis.
As submitted earlier this morning, the submissions will be presented by my learned friend, Pretorius.
May it please the Court, Justices. An overview of the submissions of the second amicus are as follows. That the social model needs to be used instead of the medical model of disability. Secondly, that due regard needs to be given to the stigmatization that we saw in the Supreme Court of Appeals judgment. Thirdly, that proper attention should be given to the cumulative effect of the multiple and severe disabilities suffered by the minor child at the center of this judgment. And then lastly, that this court needs to look at the international and constitutional norms when it comes to equality and the right to non-discrimination. So if I can go to the medical and social model, the definition of the medical model, we have moved from the medical model to the social model. And if we define the medical model describes disability as a consequence of a health condition or trauma that basically disrupts the physical and cognitive functioning of an individual. So it looks at the person with a disability and frames them inherently as having an inherent deficiency and basically a person that needs to be fixed. Where we see the social model is more focused on the barriers faced by the person with a disability. And we see this shift in movement when we get to the Convention on the Rights of Persons with Disabilities, and we see that as well in the protocol to the African Charter. And so the definition, if I can go to Article 1 of the CRPD, which is the Convention on the Rights of Persons with Disabilities, it defines a person with a disability by looking at the long-term effects of the physical, mental, intellectual, and sensory impairments of the person with the interaction with the various barriers that they face. And then the protocol to the African Charter goes even further, and it identifies these barriers as environmental barriers, attitudinal barriers, and any other barriers that a person with a disability can face. So the question is then, what does the social model basically says? And it says that we should stop focusing on trying to fix the individual, but the shift is to society and how society can adapt to a disability. And it truly is at the core of the arguments and the interpretation of the law today. So the amicus invites this honourable court to truly, in interpreting and applying the law and deciding what law is correct, to truly do it through the social model lens. And we see that it is already within this jurisprudence, the jurisprudence of this court in Makana, where Justice Rogers identified that the CRPD already signals a change from the medical model to the social model, and Justice Rogers identified that it's not the individual who needs to be cured, but rather society that must change. So the law ought to adapt to persons with disabilities. And if I can go as far as to say that we submit that the social model ultimately aligns with the principle of Ubuntu, a principle that this court is very well aware of. To mention some of the cases, Makwanyana, that we see, the Port Elizabeth municipality matter that was before this court, as well as the Everest Market, Virginia matter versus ShopRite and Checkers, where Ubuntu, the principle of Ubuntu was understood as the community or recognizing the humanity of all the individuals, and this should include, or to include, a person with a disability, especially a person with multiple disabilities. And if I can go even further to say that the core of the social model principle is that the law must not make a person's impairment a reason for denying a legal benefit that is enjoyed by others. who do not carry that same severe disability. If I can move to my second point, being stigmatization, the words vegetative state, cabbage case, retardation, these were the phrases used by the SCA in their judgment. And justices, this is not a council standing before you trying to invoke a woke culture in this court, but this is a council who understands and the importance of a singular word and the importance of defining that word and the impact one word can have. And it even, the UN Committee on the Rights of Persons with Disabilities criticized South Africa in its state party report by saying, if I can go to them, the committee highlighted that in South Africa, harmful traditional beliefs, stigma, and discrimination continue to undermine the equal protection promised by law, especially for children with disabilities. And this is what we see in the judgment. The use of the words retardation and cabbage, that is a clear disrespect and a clear violation of dignity. And we are not asking this court to police the wording used by courts, but if I can also refer this court to the African Commission on Human and People's Rights in a matter of periods and Moore versus the Gambia, where the words used in statutes like lunatics and idiots, the court found that these words dehumanize persons with mental disability and deny them any form of dignity. And that is why we put it to this court that that language should never have a place in society, let alone a written judgment by the SCA. If I go to my third point, being the interplay of the multiple severe disabilities faced by the child at the core of this matter, the cumulative effects. If we just quickly summarize inter alia the disabilities experienced by this child is cerebral palsy, visual and hearing impairments, intellectual disability, and uncontrolled epilepsy. This is just some of the disabilities that this child had. And where the SCA failed was they did not consider the cumulative effect of these multiple disabilities. It is not for us to only look at one disability and then from there, as was gathered from the questioning and the engagement with this court, that we cannot impose our normative on persons with disabilities, not at all. If I can specifically refer to our submissions from page 14 in our submissions, we speak specifically to persons with severe and multiple disabilities communicate and express awareness in very distinctive ways. There's not just one way, most definitely not. There is non-verbal vocalization, changes in muscle tone, in body posture and movement. There are psychological responses to stimuli and physiological responses, my apologies. And there are different responses to familiar voices and unfamiliar voices. There might be an eye gaze. So the communication simply does not look like the normal standards that we are used to. And we need to take that into consideration. To make so of course the question is, does this not then go to the factual findings of the court where they interpreted the expert evidence and they found that there was no awareness, no consciousness? Does this then not go to the factual argument? And our submission is, if the legal test requires a court to assess awareness through the lens of conventional neurotypical markers alone, without regard to the cumulative effect of multiple disabilities on a mode of expression, then a factual finding is contaminated by legal error. That is where we find ourselves. And if I can swiftly then move on to my very last point, and that goes to equality and non-discrimination. So the right to equality and the right to non-discrimination is trite in this court's jurisprudence, but our focus is on the international norms. What does the international court or foreign courts say about this? What does the convention say? And I focus a little bit more on the CRPD, being the Convention on the Rights of Persons with Disabilities, simply because the protocol of the African Charter, we only ratified that after the judgment in ACA. So Article 5 of the CRPD provides that all persons with disabilities are equal before and under the law. Article 7(1) of the CRPD specifically speaks to children with disabilities. And it says that the CRPD requires state parties to ensure that children with disabilities enjoy all human rights and fundamental freedoms on an equal basis with other children. That they should not be discriminated just because based on their disabilities. And then Article 12 of the CRPD goes to that a person with a disability should be recognized everywhere as persons before law. And the UN committee went on to what is defined or what does equal before the law and under the law means. I will not go into detail with that given my time, but I do want to get to intersectionality. Intersectionality, we know that Jeffries was the first case. That was in 1980 in the US, where the Jeffries matter referred to, they didn't coin the term, but there we see the first time where the court saw, but there's this intersectionality between race and gender. And then Crenshaw came in late 80s, where she finally termed the coin intersectionality, and intersectionality refers to the interaction and cumulative effects of multiple forms of discrimination. Then we see US courts refer back to Crenshaw, but Justice Victor wrote a beautiful judgment in Mklangu, and for a lack of better words, I will quote Justice Victor: "It is in this notion of multiple grounds of discrimination that the importance of intersectionality analysis becomes unavoidable." And she goes on that there is nothing foreign or alien about the concept of intersectional discrimination in our constitutional jurisprudence. She refers to other matters before this court as well, where this court recognized the importance of intersectionality. And in this matter before this court, there's a clear intersectionality, multiple discriminations. This is a child in a very vulnerable position. This is a person with a disability, and this is a black person with a disability. This is not just a double discrimination, but times 3. And if one looks at the impact that this court has in its judgment, it is going to go further to further multiple discriminations and what it truly says about it. If we go to the non-discrimination, I will just quickly refer to Canada. There were 2 judgments, but the important part was that the court cautions against reverse stereotyping, that if we ignore a disability and the effects of a disability, you force a person to sink or swim in a mainstream environment, which withholds the full and equal benefit of the law. And in Causa, in the matter of Causa, before this court, the court found that constitutional adjudication must attend to social reality, and the apparent exclusion in legal schemes must be tested against substantive equality. If we recognize substantive equality in this matter, that is just substantial. My last matter that I just need to refer to, if I may, thank you, Justice. It's a CHR, the Center for Human Rights, and the United Republic of Tanzania. This was the first disability-focused court case in the African Court on Human and People's Rights, and the state was criticized there because the state violated the right to non-discrimination by failing to take sufficient measures to combat myths and stereotypes. And thank you. Yes.
Thank you, Ms. Pretorius. I just have one question. So, how does the disability sector, which must recognize various forms of disability, ranging from the physical to the intellectual, and within each form there would be various degrees of disability, would, I imagine, generally recognize that some forms of disability may result in exclusion? So, for example, someone who is unable to see may not get a driver's license, for example, or would be unable to apply for a job as someone whose job requires them to drive a vehicle. And that would be seen as a reasonable and justifiable basis to exclude. In this case, to what extent should, if at all, the intellectual disability be a factor? I mean, in your written submissions, you take issue with the SA's judgment on 4 different bases. But what do you say this court should do and say about this case, in brief?
The submission is that intellectual disability is one of the disabilities least understood, in all honesty. And to say that, if I can differ from my colleague, to say that if there's no awareness and...
Which colleague are you differing from?
Mr. Mullins, if I may.
Okay.
If I may differ, that if there's no awareness, then one does not receive the same amount of damage. Who are we to say that their awareness is not sufficient or not at that same level? And so I do disagree, absolutely. I am trying to find my perfect words to state this, but there should not be an exclusion of an intellectual disability. And if one goes to adding awareness and adding that intellectual, intellectual awareness, this court, there's a danger of excluding a very large group, and it ought not be. Sorry.
Yeah.
Yes. Yes.
Justice Kolapen may have touched it, but I just want to get your view. What is your view on whether a functional approach to general damages can be a justifiable limitation to, with regard to a claim for general damages?
So with the functional approach, I do believe that it should only, or the submission is, that this should only be one factor of many. This cannot be the only factor that ought to be considered, and it should not be the threshold in determining general damages. Thank you. As it pleases the court.
Yes, Justice Maslantla and members of the court, I just want to make a small correction. We filed a practice note, and it's on case lines 006.2-3, and it is the penultimate paragraph where we said that the objective approach does not offend the spirit, purport, and object of the Bill of Rights. It should read functional approach. And then in that the functional approach, and not objective approach, recognizes and protects the dignity of the claimant. It just corresponds with the heads of argument. We've also made mention in our heads of argument that we may be interrupted from the outset. I think the starting point.
Just want to get to be clear, we may ask questions from the,
Very outset, because our heads are complete,
okay.
there's not really something that we wish to add to it. We respectfully submit that we get the point, we made the point that we want to make in respect of discrimination, in respect of the issue of dignity, in respect of the issue of what the common law is, what the purpose of an award is, whether it's patrimonial or non-patrimonial, and that there is no need to develop the common law.
Mr. Rousseau, you say that the functional approach does not offend the constitutional values. I looked at the development in relation to this issue, whether there's a functional approach or whether there is an objective approach. It seems to me that it has never been settled that there is such a thing as an objective approach or a functional approach, because the cases that preceded Collins are to the effect that the assessment of general damages is imprecise. You work with everything that you can work with, and you do the best you can. But the effect of Collins, which seems to be offensive, is that it introduced a threshold that excludes unconscious claimants. And now my question is that why would you not consider that to be not offensive to the constitutional values?
Yes, I think, Justice Nuku, if we look at the judgment of the SCA, what they say in paragraph 61 and the definition of Dr. Fred Plum, they quoted the definition of Dr. Fred Plum, and then in paragraph 72, they say, he therefore does not have the type of appreciation referred to above and never will until his death. In my view, the child's condition fits neatly into Professor Plum's definition of a persistent vegetative state, as referred to in Clark. Now, if we look at Professor Plum's definition of a vegetative state, and that is what the SCA said, the minor fits this description. And if one reads this description, it appears as they make a distinction between awakeness and awareness. And awakeness plus awareness is consciousness. You can be awake, but is not necessarily conscious of your surroundings. You don't have insight. You don't have insight in your condition. To use the ugly medical term, you don't cerebrate. There's no brain function. There's no brain process. But if we look at the definition, and that's what it says, the term persistent vegetative state seems to have been created by Dr. Fred Plum, professor and chairman of the Department of Neurology at Cornell University and a world-renowned neurologist. It describes the neurological condition where the subject retains the capacity to maintain. He retains the capacity to maintain the vegetative part of neurological function, but has no cognitive function. In such a state, the body is functioning entirely in terms of its internal controls. It maintains digestive activity, the reflex activity of muscles and nerves for low-level and primitive conditioned responses to stimuli, blood circulation, respiration, and certain other biological functions. And that is why the SCA said, we do not say that the child did not suffer pain. He experienced pain, but based on awakeness. Then it says,
Mr. Rousseau, I'm sorry, I'm going to have to interrupt you. My question is more at a principle level. Because the proposition I'm putting it to you is that prior to the Collins decision, the law on general damages had always been that they are imprecise. You prove them by way of evidence. What you are able to prove, you should be entitled to compensation for that.
Correct.
And then comes Collins. And then Collins draws a line to say that if you are unconscious, then there shall be no compensation. Despite the fact that there may be objectively, you may be able to prove objectively that you have suffered a loss. Let me make this example for you. You have two highly performing athletes. Both suffered debilitating injuries. One also suffers neurological deficits, which makes him unable to recognize the loss. They had been competing at the same level. In terms of the Collins approach, the other one is entitled to be compensated because he will be aware of the loss. The other one, who has suffered the same, if not more loss, will not be compensated. And I'm asking, why do you say that is not objectionable under the Constitution?
The reason is, and I just want to finish the last sentence because it connects to this argument. What it says here, but there is no behavioral evidence of either self-awareness or awareness of the surroundings in a learned manner. So, if we look at the common law, and we don't have behavioral evidence in this case of an intellectual self-awareness, we have evidence of awakeness. We do have that, but not awareness. Now, in our heads, we deal with a test as to when certain categories of damages should be awarded to certain categories of persons. And this test, and we deal with that in paragraph 43 of our heads, 006.2-16. And this is what this court stated. The notion of damages is best understood not by its nature, but by its purpose. What is the purpose of damages? To award damages must serve a particular purpose. And we say that the common law, as set out by this court in paragraphs 37 up to 41 in the Van der Merwe decision, does not contain categories, different categories, to say, well, if a person is white, we're going to award him in this particular manner. If he's black, we're going to award him in this particular manner. If he's 70 years old, there's no element of discrimination in the common law approach in awarding damages. The fact that the person is injured in a particular manner is a factor to be taken into consideration in making a fair award. If as a result of the injury, the person is in a vegetative state, that is a factor that should be taken into consideration when an award is made in respect of patrimonial damages and non-patrimonial damages. And unfortunately, in the case of non-patrimonial damages, which was negligently caused, which is a Germanic action, self-awareness does play a role. How do you console a person who is not aware even of the fact that the person is trying to console him? You award damages, you give him money. For what purpose? He doesn't benefit.
Is the compensation really dependent on the awareness? Because as I understand how these claims are quantified, you have regard to objective evidence. This is a person who was this, how old, these are the activities he used to partake in, but for the accident he would have continued to participate in those. It's got no real relationship to the feeling, but you recognize that but for the assault, he or she would have been able to engage in certain activities of life.
Yes,
And that's what you compensate for,
yes.
isn't it?
You compensate that particular person for that person's benefit and for his exclusive benefit, not his family's benefit, not for any collateral benefit, not to console the community, because the moment you say you want to console the community, it gets a punitive element. It gets a criminal element. You're punishing the person. And we must look at it from the point of view that what is the purpose? It is simply not an objective test to say, well, we must apply a flexible test.
But isn't that the test generally? That seems to be the body of law, that the approach to general damages is flexible.
It is, yes, it is flexible in the sense that one should look at that particular victim's specific circumstances.
In assessing the amount to be paid.
In assessing the amount.
Not in determining whether the person should or should not be compensated.
Yes, but on the other hand, Justice Noku, there is the saying that the law cannot compel the impossible.
So it's impossible to compensate a person who's unconscious. Is that what you're saying?
Impossible. Impossible, because where is his appreciation? Where is his appreciation of what is people trying to do to him to sort of soothe his injuries or his or the condition that he's in? It's impossible.
Thank you.
Thank you, Mr. Rousseau. I just wondered if your argument would be different if this was a general damages claim brought under the Actio Injuriarum, in terms of it there being a violation to someone's corpus or to their bodily integrity.
Justice Savage, my situation or my submission would not be any different.
So you would still require, even if there was an harm caused to their corpus in the sense of their bodily integrity, that they would still have to have personal knowledge and appreciation or consciousness.
I apologize. He has to have awareness of what he's going through.
Now, how do you marry the common law with the Constitution, given the rights that are evident in the Bill of Rights?
If we look at the award, and we must look at the award globularly, holistically. General damages, in other words, in the form of patrimonial damages and non-patrimonial damages. If you look at the patrimonial damages, if one looks at patrimonial damages that was given to the minor in this particular case, I respectfully submit that this person's, or that the minor was treated in a very dignified manner, even if he's not aware of it. Because let us have a look at what they did. In paragraph 61 of our heads, the award included cost items such as a pediatric tilt in space commode, which I believe is a ablution device.
May I interrupt you? I saw all of that.
Yes.
But are those not simply special damages, patrimonial losses that are incurred by his mother in this case, in order to ensure that he has a very basic quality of life?
Yes, but these are his damages.
Yes.
Not his mother's damages.
But the general damages seek to achieve something different. Is that not so?
Yes. But what I'm saying, Justice Savage, is that if one looks at this approach here and what was given to the minor, obviously his dignity was taken care of as best as money can buy. This is as far as money can go.
But why then do we have a concept such as solatium in the common law, and why then do we have, for instance, constitutional damages?
Yes. Solatium, as I understand it, is to console. But there has to be awareness. In the most cases of solatium, the person who is being defamed, the person who is being assaulted, the person who is being whatever done to him, appreciates the fact that he is getting something to console him. And the only method in which he can be consoled is through the payment of money.
What if one were to look at it differently and to say that from a societal perspective, in giving meaning to the constitutional rights that exist, not only for Craig, the minor child
Yes.
in this case, but to other people when they arise, when issues arise, that we require more than simply consciousness. We, in fact, as a society, give some sort of consolation, some solatium to the injured person because of the fact that the very fact that their constitutional rights have been violated.
Justice Savage, I respectfully submit that the moment one does that, it gets a punitive element. Because the person doesn't have the exclusive benefit, the person is not consoled, but the defendant is being punished by paying an amount which has no real purpose, save for consoling the community. And it has a criminal element to it.
But is it not giving meaning to constitutional rights rather than being punitive?
I respectfully submit, Justice Savage, that in this particular case, if one takes the test and the approach of the damages that was given to him in terms of the common law, his dignitas was taken care of, even if it is through an amount for special damages. He was not discriminated against. They didn't say, well, because you were unable person, we're going to treat your damages claim differently. He was disabled, or he is disabled as a result of the injury, not because he was in the first instance disabled.
What of the case of a person who's very badly beaten up by a culprit, who then suffers damages to the extent that they have no consciousness, and a person who's less badly beaten up by the same person, and they have some consciousness, or the baby who's burnt and is too young to have that consciousness of the pain, and the baby who's then 5 years old, or the young child who's 5 years old and who has consciousness. On what basis would we justify in our constitutional order that sort of distinction being drawn?
Well, Justice Savage, one should then look at the development of the common law. I'm not saying that we should not develop the common law, but as we stand here today, we have the thought process that is stated in this court as to how one should develop the common law. And I don't know how the common law should be developed, but maybe if a token amount is given, there's punitive. If an amount is given to console the community, it's punitive. Because one doesn't console that particular person, one doesn't console that particular individual. He is not aware. So what is the purpose then of the award?
All right, thank you.
Mr. Rousseau, there's an assumption that making an award of damages in the cases of someone who's aware has the effect of consoling them.
Yes.
Now, you rely quite heavily on Van der Merwe,
Yes.
a judgment of this court, but Van der Merwe tells us in clear terms there is no relationship between the money and the loss.
Yes.
So, if there is no relationship between the money and the loss, then it's hard to see how the money, well, if the money has no connection to the loss, but we argue that it serves to console you for the loss, there's a contradiction there some ways, there not.
Justice Colopin, I would say there's no real contradiction. One knows how much a packet of cigarettes costs. One knows how much a particular motor vehicle costs. But what is the value of sight? You cannot really put a money value, a monetary value on something like that. So in that sense, there is no real connection. We have to give something to this particular person who has lost his sight to console him. You will never console him.
There's an assumption that it will have a consoling effect.
Very little.
And that might be a fiction as well, not so?
Yeah. So
I mean, the example I gave earlier of a concert pianist.
Yes.
No amount of money is going to have a consoling. And
Yeah.
if it's not, could that be a legitimate basis to make the differentiation that you urge us to make between a claimant who's aware and a claimant who's not aware? Simply because in the one case, there's a hope, maybe nothing more than a hope, that it will serve some consolatory purpose as a solatium.
Yes.
And you exclude it in the other case.
Yeah, Justice Colburn, I would say that even if there is no real solace in paying a person money, it helps.
Then what's
So
its
that is the
what's
connection.
its purpose then?
It makes him feel better. If I were to get paid R1 million for loss of my one eye, obviously I won't complain. I'm not going to say no.
Yeah. I'm not sure, because in your case you might say that's too little, but anyway. Mr. Rousseau, can I ask you, in the High Court, your client never took issue with the entitlement to general damages. You took issue with the amount, not so?
Yes.
So when did that change?
That changed because I reconsidered my point. What we did there is we said, well, and that was at that point in time, my perception, my personal perception was, although the person is not aware, give him something for the fact that he indeed suffered pain. Maybe he did not have this intellectual appreciation of his pain, but he was hurt. So
what do you say about that now? Are you saying today that the facts haven't changed? That person still suffers pain, not so?
Yes.
But he's disentitled to money because doesn't have an awareness.
He doesn't have an awareness.
The intellectual awareness.
Yes.
But in the physical sense, feels the pain.
In the physical sense, he feels the pain. There is the stimuli. He reacted to that. And obviously, at that point in time, there is no real relation between that amount and the fact that the amount that should have been given to him in terms of the law. So what I'm saying is, to make myself clear, that amount was simply a gesture to give the person something, although he's not entitled to it.
And now you want to withdraw that gesture?
Definitely.
I would say that maybe then your awareness was much greater than what it is now.
Yes.
But let's leave it at that.
Okay. Mr. Rousseau, initially I hope I'm right, I'm correct if I say initially, you had an issue about the jurisdiction of the court. You had an issue about the jurisdiction of the court. Is that still the case, or do you accept that one has to deal with the dignity, which is a Section 10 issue, question of equality? Would you then accept that the jurisdiction of the court is engaged?
Well, what we say in our heads, the mere fact that we are dealing here with the development of the common law is a constitutional issue, which engages the court's jurisdiction. That is, so we can't really argue against that. So what we say is the court is not jurisdiction because the applicants do not have a reasonable prospect of success on that basis, or if in the event of it being found that is in the interest of justice to hear this application, the applicant's case should be dismissed on the merits.
Okay, that's
so it's
fine.
on that basis.
That's fine. Now, you seem to rely on the fact that special damages had been awarded, and therefore there is no basis to grant general damages.
Yes.
But why should that be the case? Because that's a separate award of damages.
Yes.
Why are we now supposed to then say just because one has received special damages, therefore they should not get the other one?
Yes, because special damages is not dependent on the It's not dependent upon awareness. He has to be compensated, he has to be placed in the same financial position he would have been in if it had not been for the injury. In other words, his negative interesse. That is what it is.
So you bring in that subjective functional approach. That's what you are talking about.
Yes.
Within,
Is
and
it-
what,
Special damages has a different formula, as already stated. You have to place you have to reward him for his negative interesse, for what he has lost, but for so place him in the same position he would have been in if it had not been for the negligently committed delict. It's got nothing to do with awareness. It's got nothing to do with consolation.
and general damages?
Yeah, general damages, in the case of the patrimonial loss, if Justice Mtlatla is referring to general damages in the sense of non-patrimonial loss, I say there's no award that can be given to any person who is unconscious, awake but not aware, because it will serve no purpose at all. It has a punitive element, and it will be difficult to ignore that. Because the moment you console him by paying money, which he's not aware of, which he or she is not aware of, who is going to benefit? Not him.
I see.
Mr. Rousseau. Let me see if I understand you correctly. Is that your submission that the minor child lacks the awareness of what is going on?
Yes.
And to substantiate your argument, you relied on paragraph 61 of the SCA judgment.
Paragraph 61.
61 where
Read with,
with Tring,
yes,
Tyrion.
yes, read with 72.
I will get there.
Justice Mato.
I will get there.
Yes.
Let's start
Yes.
here. You quoted a sentence or a paragraph that said, there is no behavioral evidence of either self-awareness or awareness of the surroundings in a learned manner.
Yes.
So what I want to put to you is, are you saying in the context of this case, the minor child had no awareness of his surroundings?
Had no awareness
of his surroundings?
Yes.
And what is your understanding in a learned manner? Because that's what the judgment says.
Yes. In a learned manner, and if one looks at this definition again of Dr. Plum, in a learned manner means in a manner where the person has insight into his condition. He can rethink it, he can process it, he can decide, well, is my condition better than that person's condition? No. He can do, it's basically using your brain.
So in other words, your argument is that insight into one's condition, it's determinative of the awareness.
Yes. So what I'm saying, Judge Matopo, is consciousness equals awakeness plus awareness. If you take away awakeness, there's no consciousness. If you take away awareness, there's no consciousness.
And pain does not feature there.
And?
Pain does not feature in that equation.
In that equation, no.
And what is that?
That is awakeness. It affects awakeness, but it's not.
So you can be awake and not aware?
Yes. like the minor in this case, awake but not aware. The awakeness part is dealt with in the first part of the definition of Dr. Plum. The awareness part is dealt with in the last part of his definition. And that is also how I understand the new terminology, with which I have no problems with, that they should call or don't refer to these patients as vegetables or cabbages or retards. I fully agree with that. It's about time, with all due respect, that that should change. And they have a suggestion there in the second amicus's heads of argument that we should maybe refer to a chronic.
No, don't worry about that. We've all acknowledged that the language may not be palatable.
Yes, yes.
But I just want to test something with you. Where the doctors say the minor child is capable of producing some vowel-like vocalizations, generally open vowels, and he vocalizes very rarely, you say he's not aware.
Not aware. Intellectually aware. That doesn't mean that the child is cerebrating. It doesn't mean that he is using his brain. It doesn't mean that he is processing thoughts.
To submit that evidence?
Pardon?
To tender that evidence?
It wasn't for us to tender the evidence. But it was for the plaintiff to convince the court that this person was aware of his
But if the
surrounding
plaintiff tender evidence from the doctors that says the child can vocalize pain, the child moans, when the child is hungry, she makes some movements, and you would say everything that the child does, it's not awareness.
Not awareness.
What is that?
It's awakeness.
Is what?
Awakeness, my lord. Awakeness.
So you can be awake and not aware?
And not aware. Yes, and that is exactly the point I've tried to make. And, as a matter of fact, that's the definition that they tendered in the second respondent, to say, they call it the unresponsive wakefulness syndrome. The unresponsive wakefulness syndrome. And what it says basically is that there's a preservation of wakefulness with an absence of awareness. You need both to be conscious.
So what you are contending and what you want this court to find is that irrespective or despite the evidence by the medical experts that the child exhibited certain outward manifestations, the child was awake, but the child was unaware.
Unaware.
And that should be the finding that is carried throughout.
Yes. Because that is exactly what...
Is that not astonishing?
No, my lord, that is exactly what... This is exactly what Dr. Plum says in his...
No. We see Dr. Plum was speaking in Tyrion's case on something else, but we now have other doctors who have opined on the condition of the minor child. Are you saying the opinions by all those experts are subservient to the opinions of Dr. Plum? They're experts.
The experts in this case, my lord, do not demonstrate an awareness. If we look at all the experts in this
case... But let's start then and get to the area of experts' evidence. Experts were called. Experts were called to assist the court in the determination of that awareness that you say, awareness or awake. The High Court considered the evidence of those experts.
Yes.
Came to a conclusion after accepting the evidence of those experts.
Yes.
Fine. And you had a quarrel with it at the SCA. The SCA upheld you. Now, how do you rely on the expert evidence of a doctor in another matter to make a determination in the matter that you're dealing with. It's an opinion. That's all that is.
Yes. But the experts in this case also gave an
Yes.
opinion.
Yeah. Now the question is, which opinion would a court interrogating the issue find favorable? A court is not going to rely on opinion from an expert in a different set of circumstances to the one currently.
Yes.
That would be dangerous.
Yes. Justice Matopu, we went through the evidence of what the experts say. We take Dr. Levine in paragraph 65 of the judgment. Dr. Levine is a speech therapist, noted the following about the minor child. He is so extremely physically impaired that he has little means of communication. He has cerebral palsy with a significant neurological involvement of the control of the musculature required for speaking, as well as profound intellectual disability. He is only capable of producing some vowel-like vocalizations, generally open vowels, and he vocalizes very rarely. He has not developed the understanding of symbolic language. He doesn't understand anything that is said to him, and he cannot express himself in words. He is not able to communicate at all except to cry to indicate that he is in pain. He does not make any connection with anybody and does not seem to recognize his mother.
And the other doctors?
Yes.
Then
Then there's
Dr.
Dr.
van der Reest says he seems to be aware of his mother's voice, but he does not turn towards her when she speaks.
Yes.
It's not awareness.
Yes. That is
No,
Dr.
but let's park it there. Is that not a patient or a minor child who's aware of the presence of his mother, the voice, but does not turn? That's what the doctor says.
Yes.
Remember, one would assume that when this patient was examined, the mother was there, and
Yes.
the doctor may have observed how the minor child reacted to the mother's voice. And you would say, this is not awareness still.
Well, then we have to reject the evidence of Dr. Levine and accept the evidence of Dr. Rest because they speak with a forked tongue. The one says, he didn't even recognize his mother, and the other one says, well, he recognizes the voice. So it's white and black here. Then we have to go to the others. And my respectful submission is that there is no behavioral evidence that carries conviction to the reasonable mind, because that is what the proof is. You have to prove something on a balance of probabilities. Where does one find in all these experts' reports anything that indicates and that carries conviction to the reasonable mind that this person is fully aware of his surrounding circumstances, that he is functioning and that he's processing?
I've heard today. Let's move away from
Yes.
that. Would it be your case that you support the functional approach? Absolutely,
Justice Matopu, yes.
And would it be your case that that functional approach, so let me put it differently. Did the functional approach, or was the functional approach endorsed and followed in Bailey? Bailey is an AD decision.
Yes. Bailey's case did not deal with a person in a vegetative state. So one should be very careful as to what is stated in Bailey. There are only 3 cases in our history that dealt with persons in an unconscious state. And that's Gurkha and the other 2, Collins and the other one.
So it would be an argument that the majority of the SCA was breaking new ground when it introduced the functional approach? Or where did they get it from? Collins, where did the SCA majority borrow the functional approach from, if it's not in any cases in South Africa?
Except the Collins case.
Is that the Collins?
Yes.
Collins was a single judge.
Yes.
Bailey is a majority, it's a SCA judgment. Starady cases tells us that you follow the judgment of a superior court, which is Bailey. But however here, the High Court, the SCA majority analyzed all the decision Gerke, Reineke, Collins, and opted to follow Collins, which is a single judge, and did not follow Bailey.
Yes, but Bailey's case did not deal with this specific question. The person in Bailey's case was not unconscious at all. We have the person in Bailey's case was not a person in a vegetative state, or in this, what they call the unresponsive awakeness syndrome. He was not.
But wasn't the principle stated in Bailey about the functional approach, applying the functional approach or not applying the functional approach? Didn't Nicholas J, whether he was AJA or J, deal with that in Bailey?
I didn't get the question.
I'm saying, didn't the judge deal with the functional approach in Bailey? I think it did.
And they also deal with the functional approach in this court.
Sorry?
And they also deal with the functional court. The Constitutional Court says that the award of damages should be looked from the vantage point of its function. That's how I understand the case of Van der Merwe.
All right. No, I can't take it any further.
Yes, thank you, ADCJ. Mr. Rousseau, can we just start with the submissions that were made by your learned friend, just to make sure that I've understood your answers? On the theory of Dr. Fred Bloom, the persistent vegetative state, which is unresponsive wakefulness, as you call it, the idea that you are awake but you are not aware of your surroundings, that's really the heart of it, isn't it?
Yes.
Yes. Now, he says, firstly, that theory was not developed in the context of assessing an entitlement to damages. This is an old theory, I think in the 60s.
Yes.
That was developed in order to decide who is entitled to live, who is entitled to die.
Yes.
And those are, for me, certainly reminders of the horrors of Germany, of the state deciding who to kill.
Yes.
Why are we dealing with that in 2026 South Africa?
My Lord, Justice, it's the question of one has to make certain what one deals with when one speaks of a person in an unconscious state. And this is the best we have.
Yes, no, I understand that, but I mean, you've repeatedly referred to Fred Bloom.
Yes.
Fred Bloom didn't examine this particular child. He was long dead by the time this child went to hospital. And his theory was not about damages. His theory was about when does the state decide to kill a person because they are living a life that is vegetative and will never improve. Now, that sounds to me to be wholly inappropriate, that we should be infusing a debate in a post-constitutional order in South Africa with such theories.
Yes, I understand the definition of Fred Bloom, and the manner in which I look at that definition is when does a neurologist, from a neurological point of view, say when is a person in a vegetative state? For whatever reason. For whatever reason. I respectfully submit that the reason is irrelevant. One should look at the definition and to say, well, if a person is like this, he's awake. If he's like this, he's also aware. Therefore, he's conscious. And that is the reason why I say that the definition of Dr. Bloom is valuable.
There is a problem, of course, in this case, as Justice Matopo pointed out, that this child is not wholly unconscious of his surroundings, particularly because they respond to the voice of the mother and they respond to the voice of I think it's the brother or the sister, according to the medical reports. So the idea that they are both awake, I mean, it's a paradoxical phraseology, awake but at the same time unaware, is not fully supported by the medical evidence. In fact, if you look at paragraph 19, 20, 21, and 22 of the minority judgment, that is the point of distinction where they say they don't agree that this child is unaware of the external stimuli and is unable to respond to the external stimuli.
Yes, Justice, as I see that the case that the Constitutional Court has to decide is based on the development of the common law. That was a factual finding.
Yes.
The one says,
Yes.
this is factual. Factually,
Yes.
we see this person as awake and aware.
Yes.
The majority says, factually, we see this as...
On that point, you and I are totally aligned. I
Yes.
needed to clear this out.
Okay.
All right. Now, can we then go to that case that you say should be dealt with, and which is, what is the South African law on this topic? Now, you have the judgments of 1966. I think that judgment was, the first one is by Ludolf J. is Gerke.
Yes.
Now, what Gerke says, it distinguishes, when it comes to general damages, between two different heads. Head one is pain and suffering. And there it says it is necessary to be subjectively aware of the pain and suffering. Yes. Head two is not pain and suffering, but what they refer to in the judgment, loss of happiness. But often we refer to that as loss of amenities. And they say on loss of amenities, it's an objective standard. Your argument today has been both pain and suffering and loss of amenities are overridden by subjective awareness. Now, if that is correct, it's actually worse than what the law was under apartheid.
Well, even if we look at I say the law hasn't changed. It is a matter of question of whether you look at it objectively and you give an objective award, or you look at it solely subjectively and you give that award.
No, I am saying, this is what I want your comment on, that even if you took Gerke, which is an apartheid judgment, even there on loss of amenities or reduction of happiness, even there the court said the standard there is objective to decide whether you are entitled to damages.
Yes.
It's not subjective awareness.
Yes,
but if you are now saying both pain and suffering and loss of amenities or reduction in happiness are subject to subjective awareness, the outcome of that will be that this court will pronounce a law that's worse than the law under apartheid. Now, that's what I want your comment on.
Yeah, my respectful submission is that Gerke was influenced by English law. Collins looked at the Roman Dutch law. The English law had an objective element there, and as your lordship rightfully point out, that the second case is basically the same as Gerke, but with certain nuances. Where they look at it objectively.
Which is, you're talking about Reineke?
Yes.
The 1991 judgment, yes.
So,
but both of those are apartheid cases. That's what I don't understand. They are both apartheid cases, and they both say, on the one head of damages, the South African law is objective. And then on pain and suffering, it is subjective. The subjective element on loss of amenities is only on the quantification.
Yes.
But the quantification may be irrelevant for this case because it's a matter of discretion.
Yes.
And there may be no basis to interfere with that discretion. But my challenge to you is that you are inviting us to express a law that's worse than the law under apartheid.
I respectfully disagree, Justice Kakobi. Now, apartheid, in that particular instance, that law that they pronounced there was applicable to each and every individual in this country, irrespective of race, color, creed, doesn't matter. And the same with the others. So there was no differentiation based on any categorization of groups and so forth. It was a law of general application.
No, the problem is that the Constitution, and that's the point I want to take you to now, I wanted to show you that under the so-called common law, your approach actually abolishes even the limited possibility of an objective application of the test for cases of the reduction of happiness.
Yes.
But under the Constitution, the situation gets worse for the government's position, because now you no longer have to find gaps in the law in order to recognize objective entitlement, as you did in the past looking at the English law.
Yes.
Now you've got expressly written down commands from dignity, which is what your colleague tried to assert, plus equality, the idea that you may not discriminate on the grounds of disability. And you would accept that a person who is mentally challenged is disabled.
Yes.
And you would accept that this large amount that was given to this child for special damages would have been more for a person who's conscious, because it would have been special damages plus general damages.
Correct.
But your client's position is no. For this particular child, only on account of their mental disability, which has resulted in unconsciousness, they should get 0 for that head of damages.
Yeah, it is based on the, yes.
Yes, but I'm saying, you are saying that in the face of Section 9 of the Constitution that expressly prohibits discrimination on the grounds of disability.
With all due respect, Judge, there is no discrimination. And the reason why I said that, and I made that point, there's no discrimination in the sense that because you are white, we are going to assess your damages in this.
I'm not talking about racial discrimination.
Yes, I'm talking
Although
about
your colleague
Yes.
for the second amici made a helpful submission about intersectionality. I'm talking about discrimination based on disability,
Yes.
which is prohibited under Section 9.
Yes, but then the discrimination should be based at the outset on disability, to say, well, because you are disabled, I'm going to treat your damages in this manner.
But that's precisely what your client is asking us to do.
No, with all due respect.
But what would you say to a conscious claimant? Would you say they should also not get general damages?
What I'm saying is, you look at the result of the injury.
No,
That
I'm
is
asking
what
you
you
a
take
direct
into
question.
account.
Would you also say that for an unconscious claimant, they should not get general damages?
Absolutely, absolutely, Justice.
And then a conscious claimant?
He should get.
And then an
Because
unconscious claimant is disabled.
An unconscious claimant is disabled as a result of the injury. And because he is unconscious as a result of the injury, he's not discriminated against because he is in a vegetative state. That is not the...
So you're saying that if the disability arises from an injury, and
the
at the time of the court awarding damages, it
Yes.
draws a distinction, that's not unfair because the basis for the award is the fact of the accident that
Yes.
they are awarding.
Because that condition is taken into account in the amount that should be given to him.
Well, that's the point.
Yes.
That condition would not be taken into account in relation to a conscious claimant. That's what I don't understand, why you are resisting the obvious fact that there is a differential treatment.
Well, the differential treatment is the moment you grant such a reward, it is punitive. Because then you console the community. And then this whole test becomes a bit, it's on a slippery slope.
Well, it sounds to me that what is on a slippery slope is the position of the government that is promoting discrimination on disability in this court.
No. I just want to place on record that that is not our submission. Our submission is that disability as a result of an injury is not discrimination. There is no law that says because you are discriminated against or because you are in a vegetative state, we're going to treat you differently than from any other person. Obviously, persons with who has lost their limbs will be treated in a certain manner. People who has lost their sight will be treated in a different manner. People who has lost whatever will be treated in a different manner. So you categorize these people for purposes of awarding damages, non-patrimonial damages.
I'm talking about people that have suffered mental disability, so don't come with other forms of disability. It's mental disability I'm talking about. A person who has had the same experience as this minor child remains conscious. On your version, they get full general damages. A person who, as a consequence of that injury, has become unconscious, on your submission, gets nothing.
Yes.
That's why I'm saying the government is promoting unfair discrimination. That's the challenge I'm putting to you.
Well, there is no discrimination based on disability per se. That is our submission.
Thank you, District.
Yes, I just want to add that in the event of the court is with us, we do not ask for a cost order when a lose. Just doesn't have to follow the result as the court is.
Thank you. Justice McClellan, Justice of the Constitutional Court. I intend to be brief. I listened as attentively as I could to arguments. I do not think that anything was, save for one exception, was deserved of a further reply and taking up the court's time in this regard. I just want to touch base on Justice Nkaitobi's interaction with my learned colleague at the end regarding the differentiation. And the differentiation which the MEC is arguing is actually no differentiation. We must always remember what you see on the photographs, what you see in Craig is the product of negligence. The more the negligence, the more severe the injury. In these types of injuries, the longer the negligence, the more severe the injury. So to argue that the differentiation is the level of the injury, that might be so. But that would give the benefit of a differentiation based upon the level of negligence. And that should not be tolerated. He is unable, he is in the position he is as a result of negligence. Children in a better position, more cognitively aware, more interactive, suffered less because they suffered less negligence. And we cannot allow such a distinction and such a benefit to arrive to the person that did this in the first place. We cannot do that. So my submission is we've invoked the court's jurisdiction. I believe we have advanced a substantial and proper argument why we believe the SCA judgment is intolerable and affronts our constitution and should be amended. We have elaborated on the relief being sought, which I persist with. So unless there's some specific questions from any of the judges, that is my reply.
There is, in the event you are successful, there is an award that was made by the High Court for these purposes. The SCA took issue with the fact that the judgment of the High Court was not properly reasoned and that it did not understand, when I say the majority, the SCA did not understand how the figure was arrived at. And as a result, it said that constitutes a misdirection. It quoted cases where courts have said parties are entitled to reasons, and it also criticized the High Court for its failure to give reasons at its initial stage and gave reasons later. So I just want to find out from you whether we are in as good a position as the High Court to make that determination, or whether is there any misdirection that can be visited upon what the High Court has ordered.
Justice Matopa, firstly, as I understand it, there was no criticism, and I don't think there's ever been a criticism as to the manner in which the court of first instance exercised the discretion, save that the SCA found that the basis upon which the discretion was exercised was incorrect, insofar as the SCA's ruling in that regard and judgment in that regard falls by the wayside. It is my submission that the judgment by the court of first instance, who exercised the discretion, and I submit properly so, there's no reason why that should not stand again. There's no criticism regarding that judgment in the first instance, save by the SCA that it was exercised incorrectly based on on this, what I propose is a legal mistake. So, no, I submit this court is in as good a position as any. The court does not sit as court as first instance regarding the quantification. And in all honesty, on just a basic consideration of the general damages awarded to children in a similar position, the award is actually fairly conservative. I think it's fair, just, and there's no reason to interfere. There's no reason why it cannot stand.
Sorry, Mr. Myburgh. The SCA took issue with the manner in which the High Court exercised its discretion, and if I recall, on two bases. One said that the relationship between special and general damages was something that a court needed to take into account because there was a relationship, and it said that sometimes the award of general damages may be influenced by the award of special damages, and explained that it said the High Court did not do that. And then I think secondly, it said that the High Court also did not make a distinction between the award of damages for pain and suffering and for the loss of amenities, and relied on authority that the High Court should have done so. In brief, it concluded that it was entitled to interfere with the exercise of the discretion that the High Court exercised, and that interference appears to be in accordance with the general principles that a court is limited to when it may interfere with the exercise of a discretion. If the SCA was correct in doing that, then it would have been correct in setting aside the order of the High Court. It may have been wrong in making the order that it ultimately made, but the net result of all of that, is it not that this court is entitled to consider the question of general damages de novo, as it were?
Justice Collopin, I think to a large extent, some of the reasons why they interfered with the exercise of discretion, and I say it with respect, fit the purpose that they were looking for. Criticizing the judge for not distinguishing between amenities and pain and suffering, I think is a criticism that was born out of this movement regarding the awareness. Had the SCA adopted the approach that subjective awareness was not a sine qua non, the issue regarding the distinction between the two, I believe, would have fallen by the wayside.
Yes, but the cases that they relied on appeared to have regarded that distinction as a legitimate one for a court to make outside of whether one was dealing with a conscious or unconscious or aware or unaware claimant.
Justice Collopin, I'm going to conclude on that sense and to say that my submission is that I think that the decision of the court of first instance can be reimposed to stand. But again, if the court finds that the court can exercise that discretion de novo and award general damages to this child, I take no legal objection to such an adoption.
Thank you very much, Mr. Myburgh.
Justice
And
Mahlangu.
thank you very much to all the parties and counsel. We are done for the day. Judgment will be reserved, court adjourned.